Good evening, everyone. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good evening, everyone. I want to welcome you to the May 16th, 2022 Zoning Hearing Master Hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over tonight's cases. Let me start by introducing Mr. Brian Grady. He's with the county's Development Services Department. He's to my left, and he will introduce other staff members that will participate in tonight's hearing, as well as go over any changes we have to tonight's agenda. Mr. Grady.
Good evening, Madam Hearing Officer. Again, for the record, Brian Grady, Hillsborough County Development Services. Before I go through the changes to the agenda and withdrawals and continuances, other staff joining us tonight virtually are with the County Attorney's Office, Cameron Clark and Mary Dorman, with Development Services staff, Chris Grandel Leonard, Isis Brown, Israel Monsanto, Michelle Heinrich, and Tim Lampkin, and with the Planning Commission, Carla Lanos. We do have three changes to the agenda. The first is just a housekeeping item regarding on page 5 of the agenda, item A17. This is major mod application 22-0416. The agenda showed as an applicant requested a continuance when that in fact is a staff requested a continuance to the June 13th, 2022 zoning hearing master hearing. The other two changes are on first other requested changes on page 7 of the agenda, item C1, rezoning standard 22-0423. The applicant is David Wright. We were informed late this afternoon that the applicant would like a request to continuance to the July 25th zoning hearing master hearing, and I believe Mr. Wright is virtually online and can explain the reasons for the request.
Okay, thank you. Mr. Wright.
Mr. Wright, you're muted.
Thank you. David Wright, P.O. Box 273417, Tampa, Florida 33688. Due to an unforeseen medical issue I've had over the past week, I've been unable to prepare for this hearing, and I'm requesting a continuance to the July hearing.
Okay. Is there anyone in the room or online that would like to speak to the continuance only, not the merits of the case, but the continuance only of rezoning 22-0423? Seeing no one in the room, no one online. All right, Mr. Wright, then we'll grant the continuance of rezoning 22-0423, which will now be heard at the July 25th zoning hearing master hearing at 6 p.m.
Thank you.
And the next change is agenda item C2 on page 7 of the agenda. It's rezoning standard 22-0456. The applicant is David Wright, and the applicant is requesting a continuance to the July 25th zoning hearing master hearing, and he is online virtually to explain the reasons for the request.
All right, one more time, Mr. Wright.
Again, Madam Hearing Officer, due to an unforeseen medical issue that I've been dealing with for the past week, I have not been able to prepare for this hearing and request a continuance to the July hearing, please.
Okay. Is there anyone in the room or online that would like to speak to the continuance only of rezoning 22-0456? Seeing no one in the room, no one online. All right, then with that, we'll continue rezoning 22-0456 to the July 25th zoning hearing master hearing at 6 p.m. Mr. Grady. Thank you.
That concludes the changes of the published agenda. I'll now go through the published withdrawals continuances beginning on page 4 of the agenda. The first item is item A1, rezoning PD 21-0745. The applicant is being continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A2, major mod 21-0963. This application that I've already heard and is being continued to the June 13, 2022 zoning hearing master hearing. Item A3, major mod application 21-1270. This application out of order to be heard has been continued to the June 13, 2022 zoning hearing master hearing. Item A4, major mod application 21-1334. This application is being continued by the applicant at the June 13, 2022 zoning hearing master hearing. Item A5, we dealt with the changes. This is a staff continuance to the June 13th, 2022 zoning hearing master hearing. Item A6, rezoning PD 21-1338. This application has been continued by the applicant to June 13, 2022 zoning hearing master hearing. Item A7, rezoning PD 22-0075. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A8, rezoning PD 22-0083. This application is out of order to be heard and has been continued to the June 13, 2022 zoning hearing master hearing. Item A9, major mod application 22-0089. This application is being continued by the applicant at the July 25th, 2022 zoning hearing master hearing. Item A10, major mod application 22-0109. This application is being continued by the applicant at the June 13, 2022 zoning hearing master hearing. Item A11, rezoning PD 22-0181. This application has been continued by the applicant at the June 13, 2022 zoning hearing master hearing. Item A12, major mod application 22-0221. This application has been continued by the applicant at the June 13, 2022 zoning hearing master hearing. Item A13, rezoning standard 22-0295. This application out of order to be heard and has been continued to the June 13, 2022 zoning hearing master hearing. Item A14, major mod application 22-0313. This application has been continued by the applicant at the July 25th, 2022 zoning hearing master hearing. Item A15, rezoning PD 22-0319. This application has been continued by the applicant at the June 13, 2022 zoning hearing master hearing. Item A16, rezoning PD 22-0369. This application has been continued by staff to the June 13, 2022 zoning hearing master hearing. Item A17, major mod application 22-0416. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A18, rezoning PD 22-0420. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A19, rezoning PD 22-0433. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A20, rezoning PD 22-0442. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A21, rezoning PD 22-0443. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A22, rezoning PD 22-0444. This application is out of order to be heard and is continuing the June 13, 2022 zoning hearing master hearing. Item A23, rezoning standard 22-0453. This application has been continued by the applicant to the August 15th, 2022 zoning hearing master hearing. Item A24, rezoning PD 22-0461. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A25, major mod application 22-0477. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A26, rezoning standard 22-0557. This application out of order to be heard and has been continued to the June 13, 2022 zoning hearing master hearing. Item A27, major mod application 22-0558. This application has been continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A28, rezoning PD 22-0559. This application is being continued by staff to the June 13, 2022 zoning hearing master hearing. Item A29, rezoning PD 22-0561. This application is being continued by staff to the June 13, 2022 zoning hearing master hearing. Item A30, rezoning PD 22-0562. This application is being continued by the applicant to the June 13, 2022 zoning hearing master hearing. Item A31, rezoning standard 22-0604. This application out of order to be heard and has been continued to the June 13, 2022 zoning hearing master hearing. And item A32, rezoning standard 22-0698. This application out of order to be heard and has been continued to the June 13th, 2022 zoning hearing master hearing. I would note just one more correction, A17. I apparently read that as a staff continuous. Is it staff continuous? Yeah, I misread on page 5, item A17. We corrected that in the changes 22-0416. That is a staff requested continuance to June 13th, not applicant. That concludes all withdrawals and continuances.
All right. Thank you so much, Mr. Gray. I appreciate it. Let me start by going over our hearing procedures this evening. Our hearing today consists of agenda items that require a public hearing by a zoning hearing master. I'll conduct a hearing on each agenda item and will file a recommendation within 15 business days following tonight's hearing. That recommendation is then sent to the Board of County Commissioners, who will make the final decision on each case we have tonight. Our hearing is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and will decide all questions of procedure. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation for tonight's hearing is as follows. Mr. Grady of the Development Services Department will make a brief introduction of each agenda item. We'll then go to the applicant. The applicant and their team has a total of 15 minutes to present their case. Next up, we'll go to the Development Services Department's staff planner that was assigned the case. That planner will have 5 minutes to go over the county's findings and staff report. Next up will be the Planning Commission. The Planning Commission will also have 5 minutes to present their findings of their staff report regarding the consistency with the application to the county's comprehensive plan. Then we'll go to proponents, anyone who would like to speak in favor of an application. Total proponent presentation time is 15 minutes. Also 15 minutes when next we go to opponents, anyone who would like to speak against an application. Everyone total has 15 minutes. We'll then go back to the Development Services Department to see if they have any additional comments or changes based on tonight's testimony. And then finally, we go back to the applicant. The applicant has the last word with 5 minutes for rebuttal to address any issues. Regarding that time for proponents and opponents, the 15 minutes, if there are a number of people that would like to speak either in favor or against an application, what I will do, and by the way, we have people in the room to speak, and we also have people that are signed up online virtually that would like to participate in the hearing as well. So what I will do is ask for a show of hands, how many people would like to speak in support, and I will count that, and I will divide the 15 minutes as equally as we can to make sure everybody has a chance. If you would like to do it, you can appoint a spokesperson for your particular case, and that person can use the majority of the 15 minutes. That's often an efficient way to get your point across. It's up to you, but we do have a number of cases tonight, and we will hold as best we can to that 15-minute time frame, both for proponents and opponents. If you are going to speak, either if you are in the room or online, when you come up to the podium or it's your turn online, if you could start by giving us your name and address for the record. We are recording this hearing both by video and audio, and we need to make sure that we have who is speaking to which agenda item and that we have your name and address correct for the record. So when you come up, you give us your name and address, and then when you are done speaking, if you are in the room, if you could see Michael, he's to my right, he's with the clerk's office. If you could also please sign in with your name, address, and the application number to which you spoke. And that's also your opportunity if you would like to submit anything into the record. When you're done speaking, you can also give Michael all of your documents, photos, whatever you would like to submit. You can give them to him, and that becomes part of the record that I will see when I go to write my decisions. So with that, let me turn to the county attorney, either Mr. Clark or Ms. Dorman. I'm not sure who's with us tonight, and they will explain the legal requirements which govern your participation at the Board of County Commissioners hearing.
Thank you, Ms. Finch. Cameron Clark, Assistant County Attorney. Tonight's public hearing is the first step of a two-step rezoning process. This hearing is the time for rezoning applicants and interested parties to present evidence and testimony. Any evidence presented tonight will become the complete factual record of each application, and no additional evidence can be introduced after the closing of each application. The second step of the rezoning process is a public meeting before the Board of County Commissioners, where the board will take a decision on each application heard tonight. Tonight's applications are scheduled to be heard by the board at its July 26, 2022 land use meeting. When considering applications, the board will only review the record created at tonight's hearing and the recommendation made by the hearing master for each application. The hearing master will file a recommendation for each application heard tonight on June 7th. The Board of County Commissioners has established a policy that directs which rezoning and major modification applications are to be placed on the consent agenda of the board's land use meeting. Applications that propose to add density outside the urban service area and applications that are on roadways with a failing level of service are not qualified for placement on the consent agenda. Applications which do not have consistent recommendations of approval or denial are also not qualified to be placed on the consent agenda. Finally, applications that have had evidence or testimony provided to the record by non-applicant parties of record, either prior to or at tonight's public hearing, are not qualified for placement on the consent agenda. The board shall allow public testimony by parties of record at its meeting to consider the hearing master recommendation for any item on the regular agenda. Any public testimony shall be limited to the record of the proceedings before the hearing master unless additional evidence has been found admissible in accordance with section 10.03.04D of the Land Development Code. A party of record is an individual who fits into at least one of the following four categories. First, someone who is present tonight and presents testimony or documentary evidence. Second, someone who is certified by the U.S. Postal Service as having been mailed notice of tonight's hearing. Third, someone who submitted documentary evidence to the master file at least 2 business days before tonight's hearing. Or fourth, someone who submitted documented evidence by proxy at tonight's hearing. Again, the content of oral argument before the board shall be limited to the content of the testimony and other evidence submitted verbally or in writing to the hearing master tonight. It's the role of the county attorney's office to ensure that only individuals who have met these requirements are allowed to speak before the board, and to ensure that no new evidence or testimony is introduced or allowed at the board's public meeting. For these reasons, please make sure all information you wish the board to consider at public meetings enter into the record tonight. Thank you.
Thank you, Mr. Clark. I appreciate it. As I mentioned, all testimony must be under oath. So if you plan to speak tonight and you're in the room or online, if you could please stand and raise your right hand and I will swear you in. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. Please be seated. Mr. Grady, let's go with the first case.
Before we go to the first item, I forgot to introduce our transportation review staff that are online tonight, and those are James Ratliff, Richard Perez, and Alex Steady.
All right. Thank you so much.
Now, the first item on tonight's agenda is item B1, is rezoning PD 18-0798, the Absence Johnson Poker Ruppel and Burns LLP. The request is a rezoning from RTC1 to a planned development. This was a remanded case that was heard, remanded a couple of times back to the zoning hearing master hearing. I will note I did hand out a revised staff report that I then neglected to include information regarding the second remand. So there's additional information in that report addressing the second remand and information regarding the Ruskin plan, community plan profile that was the subject of the second remand. And I'll provide staff a recommendation after presentation by the applicant.
Good evening.
Good evening, Ms. Finch. My name is Mark Bentley, 401 East Jackson Street, Tampa, 33602, representing the applicant. Before I get started, can you stop the timer on me? I just want to hand out a couple documents.
Sure, absolutely. Just watch all the wires. Okay. Thank you. Okay, thank you very much. Perfect.
Okay, thank you. My name is Mark Bentley. Do I have to turn this on?
Yeah.
There you go. Using up all my time turning off the buttons here. But the client's seeking a rezoning from RTC1 to planned development to allow for auto sales, which is a prohibited use in the RTC1, along with all RTC1 uses. What we are proposing this time is that the auto sales would be limited to a duration of 5 years. After that, it would terminate, and any subsequent use other than auto sales would have to fully comply with the RTC design standards. And that includes probably in this situation, demolition of the buildings, et cetera. It's kind of starting over because that's kind of the focal point of the non-compliance with respect to the RTC is the location of the building and the width, which causes the parking to front US 41. So what I have here, can we turn this on?
I see it.
Oh, okay. This is in the record, and this is the proposed design we came up with working with staff. You can see that I'll just get to the point, is that to the extent we could comply with the RTC, this is it right here in terms of buffering, screening, the auto display area, which staff characterizes as parking. It's really not. It's where you store the inventory. Also, we agreed to dedicate to the county 8 feet of right-of-way on Shell Point Road, which has an estimated cost of about $50,000. So this is the existing condition, more or less. This aerial is a little bit dated. And this is from the staff report. And this shows the general area. And Ms. Finch, what I'd point out to you is this is the subject property, obviously, right here. This property went through a redevelopment by an attorney, Mr. Santiago, and he converted from a real estate office showroom to attorney's office and emergency center. And it's my understanding he didn't have to go through any RTC, and you can see his parking is on the side of the building. So in this general area here, the only RTC compliant property is this building right here, and that's the Family Dollar store. But that business had to obtain 2 variances from the RTC. So to the extent any building would be compliant with the RTC, this one would be at the Family Dollar, obviously fully compliant because it was new construction, but for the 2 variances, and then my client's property. So the PD off. The PD does not require compliance with the RTC, although staff's applying it across the board to our situation. Exhibit 1, the staff had requested during our counseling session that we try and, to the extent possible, to implement the RTC design standards. When the board adopted the RTC in 2005, it did not contemplate that owners would be required to demolish structures upon a change of use in order to comply with the RTC. Obviously, the community would not have signed off on that. And the intent was for new construction to meet the RTC, not retrofitting. So when you peel away all the analysis in both the Planning Commission's report and Development Services, the real issue here is in terms of compatibility with the use. However, we address and mitigate that by having the use amortized out by 5 years. So auto sales would be a temporary use. This would allow our client to recoup his investment in the property and his goodwill established in the neighborhood. I'd also mention most of his clientele are lower income people who live in the immediate vicinity of the subject property and are repeat customers. The client would also comply with the RTC for the site plan to the extent possible for the auto sales. And there'd be a condition that any new use comply, and that's in the conditions with the RTC as a permitted use and with respect to design. And here again, remember that but for the RTC, when the change occurred in 2005, auto sales is allowed in CG. And if you read the RTC, it says RTC allowable uses. It says essentially, and I'm paraphrasing, CCG. Then a little further in the RTC section, it says, by the way, here is a list of prohibited uses, and one of them is auto sales, and one is motor vehicle repair. Tab 2, notably the county's then senior official before Brian got promoted, advised the board at its October 2018 hearing on this case that, and this is tab 2, I quote, in the PD proposal, the applicant from a design perspective doesn't significantly deviate from the RTC. In the proposal, at least in our estimation, what it does is it addresses the existing condition in terms of building placement, the capacity, the setbacks that are required, and recognizes that in an existing condition, and then also establishes how to deal with if the use has changed in the future, i.e. new construction. We believe that in that element of the proposal that the applicant has done a sufficient job of addressing that, but where we deviate is on the issue of use. So Mr. Morita advised the board, the way I interpret it, is that he agreed that we met the spirit and intent of the RTC to the extent we could, but they just have a problem because the use is prohibited. There was a zoning interpretation, which I think you're somewhat familiar with, issued in 2014 that concluded that auto sales was not allowed at the property as it was not the existing principal use upon the effective date of the RTC ordinance, which was 2005. But then it goes on to say in the same zoning interpretation, by the way, automobile repair is a existing lawful use. And under the lawful use as opposed to non-conforming use standard in these special districts, that's a use that can remain there in perpetuity. It's not subject to the amortization provisions or the acts of God provision, the 180 days and that type of thing. So that being said, motor vehicle repair, per this interpretation, was established as a lawful use at the time property was rezoned. So I just want to make that clear on the record, especially to the board. Maybe some of the members aren't familiar with this, that the county authorized a prohibited use as an existing lawful use that per staff is incompatible with the RTC and notably may remain in its current condition without any compliance toward RTC standards in perpetuity. It doesn't have to comply with any design standards. So what's more desirable? Temporary use that Mr. Morita indicated fulfills the intent of the RTC, or an auto repair that does not have to meet the RTC standards at all. Excuse me. Tab 5, these are in the record from last time. I just want to bring to your attention again, is that the time we got the zoning interpretation 2014, the evidence and documents we had was somewhat lacking in that the prior owner of the business there, throughout all his books and records, he had testified. So what we did at the last hearing was we had testimony and affidavits in the record, and these are in tab 5, from people who either bought cars there or worked there or had businesses in the area. And they were Buddy Harrell, Ted Piata, Donna Piata, Lee Davis, and Stephen Kukulich. And they gave sworn testimony that auto sales was an existing lawful use for several years at that location. Talk about the staff report. It mentions on page 8, second paragraph, that, quote, the applicant is seeking relief from these standards and has proposed alternative designs. Here again, we're rezoning to PD. We're not seeking relief from RTC. You know, it's a separate zoning district. As an accommodation to staff and to try to be compatible to the extent we can, we agree to incorporate the RTC design standards. I just want to make it clear that we are a separate zoning district. And that's pretty important because you'll see in a second that the county is allowed in a similar situation in the river, in the RDD, in the Brandon Town Center, I guess, allowed PDs to go in there, okay, and kind of call it zone out of those districts like the RTC. Then on page 8 of the staff report, it talks about we can't meet design standards pertaining to surface parking lots. Here again, you know, it's actually the inventory area. It's not a parking lot in the traditional sense. You know, auto sales, that's how you sell cars. You have the cars displayed. And then staff on page 9, the staff report mentions Family Dollar, and it's said it met design standards for RTC, and then it mentions one variance. And here again, that project had to get 2. There was a second RTC project. It was AutoZone, and variance 180539 had to get a variance to meet RTC as well. So it appears in roughly 17 years since the adoption of the RTC is that there have been 2 new projects. I could be wrong on that. And both projects required variances from the RTC to proceed. Planning Commission report, it mentions it mentions the Ruston Community Plan profile, which I gave you, and Brian modified the staff report to reference that as well. And the board had told me once when I was before them on this case is that it was their understanding a plan was being promulgated, and there might be some information that might be helpful to my case, or at least to take a look at it. So when I got the remand, this was being prepared, and it might have been completed. It's been so long now. And so, but you can see in the Planning Commission report, it says because it wasn't formally adopted, they didn't apply it to the subject property. But we did an analysis because it was prepared by strategic planning and Wade Trim professional planning consultants. And it has a lot of good information, and we're relying on that as part of our presentation as well. So the Planning Commission says it concludes that there's inconsistency because of the design of the site is still too much of a deviation from the Ruskin Community Plan. So it's kind of the too much. I'm not sure what that means, but you know, my response would be in light of the fact that this would be the most RTC compliant use in the area, but for Family Dollar and AutoZone in 17 years, and the fact that any other use must fully comply with the RTC design standards besides auto sales, this too much conclusion is somewhat illogical and unreasonable. And also, perhaps the Planning Commission wasn't aware that if auto sales ceases, that the PD must fully comply with the RTC. And I don't think they're aware that motor vehicle repair was allowed as a existing lawful use at the subject property. There's the issue of PD and special zoning districts. And I take you to tab 7. I know I'm running out of time here, but staff supported allowing a prohibited use through the PD and the RDD, RW. And in that case, in fact, you presided as a hearing officer, which allowed a nursing extended care through a PD, as the Riverview Downtown Development District prohibited that use. Then tab 8, another case dealt with design standards, allowed a PD in a special district in Brandon. Tab 9, letters and support. Tab 10, planning reports by Ty Maxey. Want to get those in the records. And Mr. Maxey's report has a response to all the design criteria. If you wouldn't mind taking a look at that. He goes through each criteria one by one, then provides a response. Then the strategic plan analysis, although not adopted, this plan lends significant support for our proposal and need for small independent businesses in the area where there's high minority population and lower income community and other small businesses. Our analysis of compliance is on the inside of the binder. It was prepared by Mr. Ryan Manassi. He's the planning director for Johnson Pope. So just in the inside pocket. I have the proposed conditions, which I handed out to you. If you have any questions, you can see condition number 1 relates to the 5-year limitation on auto sales. And then condition 2 says after that, everything has to fully comply with the RTC. And that'll do it unless you have any questions.
I do. I do have questions.
Sure.
So I'm reading in the, took me a little bit to go back and because obviously I've heard this case. This is the second remand, and went back through the record and my prior recommendations and so forth. And so I see the last time it went to the Board of County Commissioners on December 20th, 2019, if that's accurate. That's the change in the staff report, 2019. It was remanded at the request of the applicant to provide consideration of their Ruskin community profile, which I see that you've submitted in the binder. The most obvious question is now in 2022, what has happened between that request for remand in 2019 to today?
Well, what's happened is there was litigation associated with these applications or the zoning interpretation, which caused the courts and the pandemic, et cetera. Then we weren't sure of the status of that report, if it was going to be adopted or not. So, and I guess you could say what happened is then we came up with this idea that maybe the 5-year amortization to allow the client to recoup the investment. So that's kind of, we came to that. So in terms of my presentation tonight, I thought it was fair to kind of go over things in its entirety by virtue of the fact that there are new staff reports and they reference that strategic plan, even though they say we're not going to really consider it. You know, that was news to me that they wouldn't consider it when I got the staff report last week. So that pretty much sums it up.
Okay. Is the revised or the proposed zoning conditions that you submitted into the record tonight, the 5 years that the use would go away, the existing car lot sale would go away, was that discussed with county staff or presented prior to tonight?
No, what I did is, the client kind of struggled with that. Obviously, he didn't want to limit it to 5 years. He's built up a pretty successful business down there in the community. And it's something I suggested to him and he agreed to yesterday. So I sent an email to Mr. Grady and he was kind enough to respond. And I think I sent it to him yesterday and I'm sure Brian didn't see it till this morning. So that's the explanation behind that.
Okay. Let me just check.
And we thought 5 years would be reasonable because what he wants to do is he's developed so much goodwill down there in the community, in a customer base. He wants to find property outside the RTC where he can have the auto sales, and he doesn't have to go too far because his property is probably the last one south on the west side. Then when you go further south, there's some opportunities. So he's trying to scout down. So we thought that was a reasonable period of time for him to locate property, build a new building, et cetera.
Is there a code enforcement case on the property?
No.
Was there ever?
Yeah.
And that's been resolved?
Well, it's not active.
All right. So it was closed?
Yes.
Okay, perfect.
I can't say as of today. I haven't looked on, is it optics?
Yes.
I haven't looked on but last time I looked, there was no active case.
All right. Thank you. That's the end of my questions.
Okay, thank you.
If you could please sign in, please.
Sure.
Thank you so much. We'll hear from Development Services.
Brian Grady, Hillsborough County Development Services. The request is rezone a 0.52 acre parcel from RTC 1, which is Ruskin Town Center, to planned development to allow use of permitted under the RTC 1 zoning district and motor vehicle sales, which is a permitted use in RTC 1. As was discussed, this was remanded twice from the Board of County Commissioners. The first time to allow for further review discussion with the representatives of the Ruskin community, which I believe did occur during that first remand. The second remand, as referenced, was to requested by the applicant to provide additional provide for consideration of the Ruskin community profile. As noted by the applicant, that since the previous zoning hearing master hearing, no specific change in the request has been made other than the recent proposed changes that he submitted tonight regarding limiting the use of the vehicle sales for 5 years and relinquishing the ability to do auto repairs pursuant to the reference zoning interpretation. But principally, the main use that they're trying to get is, again, the car sales, new and used, which has not changed since prior hearings. With respect to the site plan, the only changes since the last time, this was before the zoning hearing masters, the applicant did make some revisions to the plan to add cross-access points and relocate some parking to accommodate the cross-access, and then added notations regarding providing for 8 feet of right-of-way preservation area along West Shell Point Road. The revised report handout today does provide a summary of the Ruskin Community Plan profile, which provides information regarding build-out scenarios for certain areas of Ruskin, specifically Ruskin Town Center, College Avenue corridor between US 41 and I-75, and then also the South Shore Corporate Park. the report also contains community-wide socioeconomic employment, population infrastructure, and community facilities analysis and trends. As noted, the Planning Commission did note that the Rusk community profile is not an adopted document, and they cannot use it in their analysis when making land development regulations. Again, given that the use has not changed, staff's analysis and non-support with respect to compatibility and compliance with the Ruskin community design standards remain as previously noted. I will note that in response to the applicant's reference to staff presentation at prior board meetings, I think, again, that was in recognition of the applicant's effort to attempt to comply as best they could with the standards of the Ruskin community design standards, given the existing use and trying to accommodate that existing use. I will note that it is standard practice when parcel has one of these special zoning districts, whether here and in another, as he referenced, the Riverview, Uptown, Downtown districts and similar districts, as standard practice that if you're not permitted from zoning out of that district, that zone district, staff does look to those standards from a general compatibility and consistency with the intent of the requirements that promulgated the rezoning of those districts. So we generally will apply those standards and look to those and ask, work with the applicant to provide justification for seeking relief from those standards. So that's not uncommon. And but again, each one's handled on a case-by-case basis to whether or not ultimately staff would support those proposed changes. And again, in this instance, as noted in this report and prior reports, we did not find the use consistent with the intent of the Ruskin community plan and the RTC development requirements as adopted in the Land Development Code, and the use not consistent with the surrounding development plan as wouldn't be allowed under the RDC1, which is what's the surrounding districts to this proposal. Therefore, overall staff does not find the requests supportable. I will note with respect to the proposed condition regarding the limitations of the 5 years. And if you have any further questions on this, I'm sure county attorneys can weigh in on this also. But from our perspective, from a compatibility standpoint, notwithstanding the limitation of 5 years, we still, compatibility is still relevant, whether or not the use is there for 5 years or in perpetuity or for 10 years, or, that compatibility analysis is still relevant. So that, from our perspective, doesn't change our analysis. Thank you.
So that was that was the point of my question, the latter part of your testimony. So in summary, the county's position is that the proposed use or the existing use that they would like to recognize of motor vehicle sales is inconsistent with the development pattern in the area.
Correct.
Okay. And that the proposed 5-year transition to recognize that for 5 years and then have it be removed does not change your staff's opinion.
Correct.
Recommendation. All right. Thank you so much. We'll go to the Planning Commission.
Carla Llano, Senior Planner with Planning Commission staff. The subject property has a future land use designation of Office Commercial 20. It's within an urban service area and is within the Ruskin Community Plan and the South Shore Community Plan. The applicant requested a remand of Plan Development 18-0798 at the October 9th, 2018 Board of County Commissioners Land Use Hearing meeting. The board approved this remand to be sent to the November 19th, 2018 Zoning Hearing Master Meeting for reconsideration. The Board of County Commissioners approved a second remand at their December 20th, 2019 Land Use Hearing to go before the Zoning Hearing Master on January 21st, 2020. This remand was to address the Ruskin community profile. Since then, the application has been out of order several times and subsequently been continued by the applicant until now. The applicant is requesting a rezoning from Ruskin Town Center 1 to Plan Development to allow for an existing vehicle sales business and other permitted RTC or Ruskin Town Center 1 uses. It should be noted that the site underwent a zoning verification in 2014. It was determined by the Development Services Department that the site failed to establish the motor vehicle sales was an existing lawful use. At the time of the establishment of the Ruskin Town Center 1 zoning district, Planning Commission staff stated in the staff report specifically that the proposed development is not consistent with policy 9.2. The proposed development encourages strip commercial, which is not envisioned in the Ruskin Community Plan, and is also consistent with Objective 23 of the future land use element. Planning Commission staff identified screening issues, though the applicant is providing an increased screening along the frontage of the site and is also screening the waste storage and mechanical equipment area. The proposed design still of the site is still too much of a deviation from that Ruskin Community Plan. Therefore, based on those considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County.
Thank you very much. I appreciate it. All right, we'll go to proponents. Anyone who would like to speak in support of this application? Or is there anyone in the room that would like to speak in support? If you could raise your hand. Seeing no one, anyone online for support? All right, and seeing no one, anyone in opposition to this request? You could raise your hand if you'd like to speak. So we have 2 in the room. Anybody online? No. Okay. If you want to both come forward. You have, we're going to split the time. So you have about 7.5 minutes each. You could start by giving us your name and address, please. Good evening.
Good evening, Sandy Council, P.O. Box 1115, Ruskin, Florida, 33575.
Thank you.
I'm president of the Ruskin Community Development Foundation, and we are in support of staff's recommendation. And we submitted a letter to staff on August 13th, 2018. Our position has not changed, where we pointed out the reasons why we are not in support of this rezoning. I would like to reread into record one statement in this letter. The board agrees the request is inconsistent with the RTC 1 element of the Ruskin Community Plan and should be denied. Community plans adopted into the county comprehensive plan by the BOCC took months of staff time, community participation to develop and come to a consensus. While it is very clear from the beginning there was no funding attached to these plans, it was a realistic expectation of the people involved that the county would support the intent of the individual community plans and projects as they came forward, especially when there were inconsistencies. Our position remains the same, and we ask that you continue to not support this or to deny this.
Thank you very much for coming down. If you could please sign in with the clerk's
Absolutely.
office. Good evening, sir.
Good evening, William Breadbinner. I'm also with the Ruskin Community Development Foundation. I'm the treasurer. I reside at 109 2nd Street Northwest in Ruskin, Florida. I do want to say, as Ms. Council said, we do support the inconsistency and not moving forward with it. We did try to work with them and with the zoning department to see if there's a way. We like to support business in the community, but we also need to preserve the RTC. If there is any variance to that, then this opens this for anyone to apply for plan development and pokes holes into the RTC and sets precedent. So we want to see this preserved. I would like it explored as far as I'm aware, and I just tried to check the optics. The auto zone is fully compliant, and I'm not aware. We were not informed of any variances made for that, and it is an RTC1. And I don't see anything in optics that shows that they were that they requested a variance, and I believe we'd have been notified. So when it goes to commission, I would like for that to be in the record. If there was a variance granted, it's not one that Ruskin Community Development Foundation was aware of. In fact, I was using that as an example of what a compliant RTC1 project should be. It is driveway on the side, parking in the rear, and all of their display windows are along the frontage. They even have a handicap accessible walkway up the front to the front door. Thank you.
Thank you so much for coming down. If you could please sign in. All right. Not seeing anyone else to testify in opposition, we'll go back to Development Services. Mr. Grady, anything further?
Nothing further.
All right. And Mr. Bentley, you have 5 minutes for rebuttal.
with respect to this issue about the auto zone, not that it's going to save the day here, but it was not fully compliant with the RTC, and it was case number VAR 18-0539. Okay, that was a setback variance. Also like to get into the record, I know it's there, but maybe I think it's probably not that visible. Last time I looked at the record, there's about 500 pages, but the zoning interpretation, which here again states that the applicant proposes to reconfigure the land use for motor vehicle repair use, which was established at the time the property was rezoned. So I think it's important that the board know that in this situation, that there's a balancing act here, that they have the opportunity to eliminate an ugly use as prohibited on the RTC in exchange for a temporary use that's the use it doesn't comply, but it's mitigated by compliance with the RTC design standards to the extent possible. And thereafter, any development at that key corner in Ruskin would be completely RTC compliant. And by that, we don't mean like try to retrofit. We mean by clean slate, demolish the buildings on the property, and there'd be a complete redevelopment. So that's what we're looking at, to give this gentleman the opportunity to recoup his investment at the subject property. So I appreciate your time. If you have any questions.
I do. On that point, has this property owner, when did he buy the property? How long has he owned it?
And here again, I'll just give you a rough time frame.
Approximate, that's
Okay,
fine.
approximately 2013.
2013. Okay. So you testified that the property was rezoned by the county to RTC in 2005?
Yeah.
Okay. So he bought it under the RTC category.
Yeah, but here's I guess the major rub to give you a complete answer is when they did the area-wide zoning, okay, the owner of the property testified and submitted an affidavit that on an area-wide, you don't get direct notice. So the way the RTC is drafted, and this has come up with a lot of other owners apparently who caught wind after the fact when the RTC was adopted. When you read it, it says all CG uses, which made auto sales and auto repair that sanctioned that under the RTC. But when you go a few pages in, it says, by the way, here are prohibited uses. That wasn't really advertised, okay, first of all, in the advertisement. And second of all, your typical layperson is not going to know that, hey, I better look a little further because there's 10 or 12 uses here that are prohibited. So everybody was proceeding in good faith and thought that our uses were fine, you know?
And that was an issue that was brought up, as I recall, in your zoning interpretation request, that argument.
Yeah, it's been brought up. And you do this for a living. It's a pretty legitimate, fair argument, you know, especially for a layperson that is not following the Tampa Tribune. And actually the ordinance that adopted the RTC didn't just adopt the RTC. It adopted several of these different, I'll call them overlay districts. So you really had to be on the ball to figure out that you're going to be an affected property owner in the Ruskin area on 41.
Let me ask Mr. Grady one question, and then I will let you have the last word. Mr. Grady, that regarding that zoning interpretation from 2014, I believe.
Yes,
correct? 2014. So Mr. Bentley's argument and applied for the zoning interpretation, that interpretation by the, thank you. Is that something that's obviously in the record, but okay, perfect. That interpretation was denied by the zoning administrator and appealed to the land use hearing officer, who upheld the zoning administrator's opinion to deny the request that the vehicle sales use be permitted to continue.
Yes,
Is that
that's what I'm
correct?
saying, yeah.
All right. Is there anything you want to add to that discussion before I go
Nothing
back?
further.
All right, Mr. Bentley, I'll give you the last word.
No, I don't want to beat a dead horse here. So,
All right.
Okay, thank you.
Thank you
Appreciate
for
it.
your time. I appreciate it. With that, we'll close rezoning 18-0798 and go to the next case.
The next item is agenda item B2, rezoning PD 20-1253. Excuse me, this is a request for rezoning from ASC1 to planned development. Madam Hearing Officers, this is remanded by the Board of County Commissioners. I will provide staff recommendation after presentation by the applicant.
All right. Good evening.
Good evening, Cami Corbett with the law firm of Hill Ward Henderson, 101 East Kennedy Boulevard, Suite 3700, representing the applicant. And I do have a PowerPoint, and I'd like the one that is labeled remand hearing. Perfect.
I see it.
Next, go ahead and get that in. There you go. Next slide already, please. Just to remind you again, this was a development proposal for a state-of-the-art 7-Eleven in the Lutz Community Plan. It's a brand new building. It fulfills a need in a market, and the developers are committed to being good neighbors. Next slide. So yes, this was remanded. It was actually a pretty close remand. The commissioners had quite a bit of discussion about the application, and there was actually a motion to approve the development. But there were several questions that remained specifically about the car wash and how the car wash was going to function and what the impact of EPC was. And so after further discussion, I think they decided, well, we probably need to hear from EPC. And they did actually ask us if at that time, if we would be willing to remove the car wash. And at that point, we hadn't talked with our end user and really weren't in a position to remove that at that time. But we have been able to remove that, and we were able to eliminate that as any issue of concern or consideration for the board. Also, they talked about lighting impacts and concern about lighting impacts. And so what we did was prepare a photometric plan showing what our clients' requirements are, our end users' requirements are, and showing compliance with the land development code. And there's actually now condition 5 in the staff report, which reflects the limitations of that photometric plan. And then lastly, Commissioner Smith did want to make sure that the remand was open to hear additional testimony and evidence from the community. And then the last issue was something that came up after the remand. The original wetland ditch that was on site ended up, after delineation, being a little bit larger than the EPC had anticipated when they initially reviewed it. So they did require additional submittal of information and review, and we'll be addressing that this evening as well. Okay, next slide. Again, here's the revised site plan showing the car wash removed. We actually did include another 0.3 acres of property to enable us to shift and accommodate to try to minimize the impacts of the wetlands. Next slide. And we are an 84%. We were an 82%, now we're 84% reduction in intensity. Again, condition 5, this is the photometric plan. You can't really see it very well on the slide. I've got a hard copy that I'm going to submit to you so you can actually read what the foot candle sizes are. I've got an 11 by 17 copy for you. We are 60% less than the maximum that's allowed by the code on the north, which is facing the residential, and 30% less than the maximum on the other sides. Next slide. And since that's a two-dimensional, this is sort of a three-dimensional plan. This was actually prepared before the car wash was removed. So if you can imagine, with the car wash removed even further, there'll be fewer light impacts. That's sort of the night vision view. And then next slide. Again, likewise, a rendering that shows the illuminance in the foot candles. You see the blue, dark blue is 0 illuminance emitting from the property boundary, going to the green, and then the more intense right around the front of the store, which faces US 41. Next slide. We've had additional party of record in form of written testimony so far. And essentially, we've got an objection to the location of the hearing. We've got an unrelated general environmental article. We had an email from someone concurring with EPC's prior objection, which has now been removed. And then generally, there's been a resubmittal of similar information that you heard at the last hearing about the 2005 zoning request, the fact that there's a private well, the fact that there's development at the intersection, and then now there's opposition to the wetland impact. Next slide. And that takes us to the wetland impact. And at this time, I'd like to have Dale Merriman come up and present to you regarding that.
All right. Thank you so much.
And Mr. Merriman, when you come up, could you please qualify yourself as an expert?
Good evening.
Good evening. Dale Merriman for the applicant, 10408 Bloomingdale Avenue, Riverview, 33578. And as she said, I am an expert. I do expert witness testimony in court and have been doing environmental services for 48 years. basically, what I want to do is just bring everybody sort of up to speed on the new rules and regulations on wetlands. In December 31st of last year, Corps of Engineers turned over their regulations to DEP. And since that time, the state water management districts, DEP, and the Corps all use a new form of assessment of what a wetland would be. In this particular case, it includes, did you submit the, okay. My documents. No, I gave them to you. Sorry about that.
That's okay.
It requires usually three things, which is wetland hydrology, hydric soils, and then also plants or hydrophytic plants. In this case, this was an old orange grove. I will submit a 1965 aerial, which clearly shows the orange groves, residences on this property, as well as other types of use for the property. There was a ditch in the southeast corner that basically drains because of the elevations. It drains any of the water that's up on the orange grove down towards a historic wetland, which is off site. There are, and I won't bore you with the details, but there are 4 different tests that you can apply to determine whether it is a wetland or not. And in this particular case, 3 out of the 4 do not apply. One being the wetland plants has to be 80%. There's only 40. It should also be pointed out that there are no unauthorized alterations. Hence, the wetlands did not grow in any way, shape, or form. One thing that you'll see in the data is that the orange groves, when they were removed, as you can imagine, your big root ball, it leaves a depression, and that's what it did down in this corner. So that the ditch now has expanded a little bit, but not necessarily being a wetland because it only has half wetland and half upland plants. So one last thing, and then I'll wind up. The formal outline would need either a surface water connection or a wetland connection to off-site wetlands. And in this particular case, this wetland is determined by the district and ourselves as being an isolated wetland on site. And I will put into record the information.
Mr. Merriman, just a quick question. So
Yes,
the
ma'am.
change, is it accurate to say the reason the wetland was determined to be larger was the change in how it's reviewed? Is that correct?
Yes, it was how it was reviewed, and then also the fact that when you remove a lot of soil or remove plants or trees, it leaves a little depression, almost like a little swale around the ditch. So anytime the ditch filled with water, some of it would percolate out of the ditch.
Understood. Thank you so much. If you could please sign in.
Yes, ma'am.
Cami Corbett again for the record. Next slide. Just with that, again, we have a revised staff report from both Planning Commission and Development Services, and we are still found to be consistent and compatible with both the comprehensive plan and the Lutz community plan. And with that, I would like to reserve our remaining 7 minutes for rebuttal.
All right, fair enough. Thank you so much. Development Services.
Brian Grady, Hillsborough County Development Services Department. The request is rezoned from ASC 1 to planned development to allow for a 5,000 square foot convenience store with gasoline sales. The parcels in the Lutz Res 2 plan category in the Lutz community plan area. As noted, this was remanded by the board to address issues regarding potential water quality impacts of runoff associated with the car wash that was previously proposed as noted by the applicant. The applicant has remove that from their request. As noted, the applicant did also, in response to a request for additional information regarding lighting impacts, did provide a photometric lighting plan. And as noted, conditions have been added regarding provisions of maximum foot candles at project boundaries in response to what was provided in that photometric plan. As noted by the applicant, the wetland did grow larger, and the applicant did provide a revised plan to show the updated boundaries of that wetland. Environmental Protection Commission reviewed the revised plan and has commented the project as submitted is conceptually justified to move forward through the rezoning review process, subject to recommended conditions, which have been included in the conditions of approval. With respect to those, an additional condition has been added regarding requirement for additional stem wall and retaining walls and curbing guttering of the driveway to address and ensure stormwater flow away from the wetland area, depending on where that new wetland line is. If subsequent to zoning approval, EPC does approve those wetland impacts. I would note also one additional change to the prior staff report. It's regarding the condition regarding the relief from the pitched roof standards of the loose community plan. That condition has been updated to correctly reflect the relief from the requirement is applying to the entire the building side as opposed to only the eastern building facade. The proposed rendering that was deemed acceptable has not changed from the original submittal. The prior condition incorrectly only applied relief from the standard to the eastern building facade, which does not contain the proposed slope parapets. While the slope parapets along the north, south, and western boundary facades provide a visual approximation of a pitched roof, they do not constitute per the LDC a pitched roof, and therefore the condition was updated to clarify that, because it incorrectly referenced just the eastern building facade. Again, staff prior to the remand did find this request consistent and approvable, subject to conditions, and with the revisions as outlined by the applicant, staff is still finding this approval subject to conditions.
All right. Thank you so much. Planning Commission, please.
Carliano, Senior Planner with Planning Commission. The property's future land use designation is residential 2 and is located within the rural service area. Property is also within the Lutz Community Plan. The application was heard on October 12, 2021 at the Board of County Commissioners Land Use Meeting and was then remanded back to the Zoning Hearing Master. The item was then continued by the applicant to address concerns expressed by the Board of County Commissioners at the aforementioned meeting. The applicant requests to rezone the property from agricultural single-family conventional 1 to planned development, allowing for a 5,000 square foot convenience store and a 14 pump gas station. The applicant has previously removed the proposed car wash. Some of the concerns brought forth on the October 12, 2021 Board of County Commissioners Land Use Meeting was lighting, the potential car wash runoff, and meeting the vision of the Lutz Community Plan with regards to the commercial nodal placement. To address those issues, the applicant has removed the potential for the car wash, as mentioned, from the plan development application. It has submitted a photometric lighting plan. It should be noted that Planning Commission discovered that the site does meet commercial locational criteria as outlined in the future land use element objective 22. Approximately 75% of the site is located within 900 feet of a 2-lane roadway, Sunset Lane, and a 4-lane roadway, US Highway 41. Therefore, the site not only meets the vision of the Lutz Community Plan by being near a node identified in the plan, but it also meets the traditional application of a commercial locational criteria by being within 900 feet of a qualifying intersection. This is considered consistent with the policy direction. The proposed request is consistent also with Objective 16 and all these subsequent policies addressing compatibility with surrounding issues. The proposed development is consistent also with the community design policies, as the applicant is proposing cross-access between the site and the balance of the property. Planning Commission is supporting the variation from the pitched roof, as an overall, the overall design will maintain a rural character. Based on upon those considerations, Planning Commission staff finds the proposed plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to conditions proposed by Development Services Department.
Thank you very much. I appreciate it. Is there anyone in the room or online that would like to speak in support? Anyone in favor of this request? Anybody online? All right. Anyone in opposition to this request? How many do we have in the room that want to speak? So I see 3, 4, right? Anybody online? One person. So we have 5 total. So if you all want to go ahead and come forward and line up, we'll give you 3 minutes apiece just to make it fair. And we'll start with the people in the room and then we'll finish with the last person online. Good evening.
Very good. Zoning hearing master, my name is Luke LaRoe, 2240 Bel Air Road, Clearwater, Florida. I represent a number of citizens in opposition to this. And we were here during the October board hearing with the county commission. And I think it was clear then that there were some grave environmental considerations that had not been brought before you when you heard it the first time. And then it had been over 6 months in working with this. I listened to Mr. Merriman, and it sounds to me like the shift in designation as a wetland has been more administrative than anything else. From our perspective, that's form over substance. And the big concern that we had was not just the car wash, it was also the underground tanks. And I think everybody here realizes the threat that they pose. My clients are not opposed to development. I just don't want development that has 14 gas tanks and different vending areas for that. And it just is way too intensive to be compatible with this area. And I hate to ask that you take somebody out of turn, but if you could call our expert is Max Forgy. He's the one that's
Is he online?
Zoom. He is online.
Sure.
And I don't want to eat up any more time, but I urge you to deny this request.
Thank you so much. If you could please sign in.
Thank you.
All right, we'll take the next person, the online.
Max, go ahead.
Good evening. My name is Daryl Max Forgy, doing business as Forgy Planning, 236 Southeast 45th Street in Cape Coral, Florida. I have been sworn. I have more than 35 years of experience as a professional land use planner. I earned the MPA degree in urban and regional planning from the O'Neill School of Public and Environmental Affairs at Indiana University, Bloomington, and have been a member in good standing of the American Institute of Certified Planners since 1993. Because this is a quasi-judicial proceeding, the burden upon the applicant and the county is to satisfy the twofold Snyder test. First, the application must be consistent with the comprehensive plan and with the procedural requirements of the zoning ordinance. This application is not consistent with the comprehensive plan. It is inconsistent with the crucial definition of compatibility in Florida statutes, chapter 163.3164, paren 9, which states that compatibility means a condition in which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted directly or indirectly by another use or condition, end quote. It is precisely in situations such as this one where the testimony of neighbors is most competent and substantial. They are the ones who have lived in the neighborhood and have a firsthand sense of the likely long-term impacts of traffic, noise, light, dust, and other concerns. The Hillsborough County Comprehensive Plan has plenty to say about rural land uses. Future land use element page 1 states, quote, "The rural areas are that area planned to remain in long-term agriculture, mining, or large lot residential development. Within the rural area, some rural communities exist. These communities have historically served as a center of community activity within the rural environment, and they include LUTs and others. The diversity and unique character of these communities can be reflected through the application of what is called community-based planning techniques, specifically designed to retain their rural character while providing a level of service appropriate to the community and its surrounding environment."
Mr. Forgy, let me interrupt you. I apologize. You just finished your 3 minutes, but because you are their expert, I'll give you another minute to wrap it up if you don't mind. But we do have other people that would like to speak.
It was my understanding that our group received 15 minutes and that we were planning for that 15 minutes.
We do. That is correct. But we had 5 people to speak. Mr. LaRose started. You were second. If these folks would like to keep their time down to a minute each, if they want to, you would like your full 3 minutes.
I can wrap up in 1 minute.
That'd be great. Thank you very much.
Go also to page 7, which refers to rural communities and their uses, to policy 4.1, and the scale of development, specifically the 1 dwelling unit per 6 gross acres density. I understand this is an intensity of use. The subject property is located in the rural service area. It is not urban, and it is the clear intent of the comprehensive plan that it remain in long-term agriculture, mining, or large lot residential development. There is no evidence on the record that the proposed use was the result of a community-based planning effort. There were 3 specific policies cited in the hearing examiner report: 16.1, 16.2, and 16.3. I do not
Just
have
finish your sentence, please.
to impeach those. Jay Muffley and Sam Calco will address the wellhead protection area and other issues of importance to their neighbors in Lutz, which they raised at the BCC hearing in October. That concludes my remarks.
Thank you so much. I appreciate that. Next, please. Good evening.
Good evening, Your Honor. My name is Sam Calco.
Good evening, Your Honor. My name is Sam Calco, 18422 Swan Lake Drive, Lutz, Florida, 33549. I'm also a board member of the Lutz Citizens Coalition, and I am speaking on behalf of myself and our members. This case was initially to be heard in December of 2020, but it's been continued for more than a year by the applicant and the Hillsborough County planners to tonight's last possible hearing date of 5/16/22. Applicant was told by HCEPC just a few short months ago that there are significant wetland impacts. And Kevin DeFrank of the Hillsborough County Planning Commission told them they would be denied their request at the ZHM meeting that night. HCPC continued that hearing. Applicant has submitted changes in drawings, blueprints, taken the car wash out, whatever. But what never changes is the land that it will be built upon. And this is not the best available nor suitable for sale piece of land in Lutz or even on US Highway 41 in Lutz to build upon due to severe wetland impacts. The owner is under no hardship to sell this land, as he recently sold the adjoining land he owned to Sierra Builders for $1.3 million for future residences. The owner sold the next door property at the corner of Sunset and US Highway 41, which became the site of the current Walgreens. At that time, the Hillsborough County Board of County Commissioners conditioned that property due to water, private wells, wetlands, septic tanks, et cetera, to 19 uses. They specifically said what you cannot build: gas stations, car washes, dry cleaners. Many things with toxic materials were not allowed. It only follows that this site, which is even closer to the wetlands and a private water wells, would also be equally conditioned. There are no sanitation sewers here, only septic tanks. Gasoline and septic tanks are not compatible. The wetlands also flow from this property. Can I get a picture here?
I see it.
Okay, you see where the yellow dot is? That's where they want.
Sir, you turn on the other mic. There.
Thank you. As you can see, the yellow dot, here's the wetlands. Here, they go right underneath Sunset Lane, all the way to Lake Stemper. Now you can see the flow. I will give you this map along with my testimony tonight. But turn this back on. Okay. It is even questionable as to who has the jurisdictional authority over the decisions on these wetlands: HCEPC, HCPC, BOCC, or maybe even the federal EPA. We will know at the time of the BOCC hearing in this case. Mitigation does not work for this property. We're not putting a 9x12 shed in someone's backyard here. We are talking about our environment, water, wetlands. There will be damage and negative impacts. For example, gas station storage technology. Why must it always be upgraded? Because they all fail. Our contention is current tank storage technology, the latest and greatest they boast about, has not had enough time or a track record of service to know what it's going to do. The newest technology that they're speaking needs about 15 to 20 years of service before they can definitively tell us it's safe. The property is currently zoned ASC1 with an upcoming upgrade to RM2, which is the proper zoning for this land. Lutz is in the rural service area, not the urban service area. Applicant told us at a community meeting prior to the August 2021 ZHM meeting, other sites for this proposed 7-Eleven were considered. We contend there are, and the citizens group in Lutz look forward to working with the applicant to identify other suitable sites and eliminate others. They should be agreeable, work with us in good faith and not after the fact as they did in this case.
Sir, if you could wrap it up.
I will. The upgrade to this intersection of US 41 North and Sunset Lane has no impact on the project. Those upgrades are designed to help traffic flow going from Sunset Lane West to US 41 South away from the proposed 7-Eleven, and also a much smaller amount of traffic going from Sunset Lane East to US 41 North, 2 lanes closest to the median. This is in writing. I'll wrap it up here.
You can submit that into the record.
Yes, thank you. Finally, Madam Hearing Examiner, we wish to restate the testimony of our expert planner, Max Forgy, who stated the application as proposed is inconsistent with the statutory definition of compatibility. The proposed use is incompatible with the neighboring rural uses in both content and intensity. It is incompatible with the Hillsborough County Comprehensive Plan, future land use element, and the Lutz Special Area Plan, and therefore does not meet the first crucial test of the twofold Snyder test. For these reasons, we ask that you return this application to the Board of County Commissioners with a recommendation for denial. Thank you.
Thank you. Please submit whatever you'd like into the record and sign in. Next, please.
Yes, ma'am.
Good evening.
Jay Muffley, 102 Fifth Avenue Southeast, Lutz, President of Lutz Civic Association. How much time do we have left?
3 minutes, but we seem to be extending by a minute or so, so I'll give you the courtesy as well.
Okay, thank you. And we need some time for.
Yes, sir.
Okay. How is this?
We'll afford that to the applicant as well, just to be fair. So go ahead.
Let's see. All right. All right. The Lutz Civic Association opposes this rezoning with wetlands on the property. It would be a threat to our environment, the wetlands, the wells, public and private, and the Lake Stemper. Looking at the wetlands on the K8, you can see that they.
Sir, could you move the microphone closer to you? Yes.
They extend from Lutz K8 school down through here, over onto the property, under Sunset. They flow under Sunset Lane and on south. Looking at the next aerial, you'll notice that they flow from the site all the way south. Here's Sunset Manor that has a public well permit, all the way along Cypress Cove Road to Lake Stemper. They flow constantly. This is their water permit, and their public use permit. The Lutz.
Just stay close.
All the wells along Cypress Cove are private and connect the Lutz Civic Association is against any use that would endanger our environment. The wetlands, the wells, and the lakes. We oppose any wetland mitigation for this rezoning. In fact, we oppose any loss of wetlands. We respectfully ask that you deny this petition. Thank you.
Thank you, sir. I appreciate it. If you could please sign in, and you're welcome to submit those documents if you would like into the record. If you would like to submit your documents into the record, you're welcome to. Yes, ma'am. Good evening.
Good evening.
Good evening.
My name is
You
Susan.
can just bring this down to just a little bit. There
My
you
name
go.
is Susan Guess, 505 Old Grove Drive, Lutz, Florida, 33548. My family is Tampa natives, and we are Lutz residents for the past 34 years. During this time, the habitat around us has been a refuge for many different animals and birds. I worked for Barton Ashman. They were traffic and transportation planners. and they are a subsidiary of the Parsons Corporation, and I was educated in this field. I also was employed by a company who did underground storage tanks and recommended when they be dug up because they were leaking. We do have a storage company that had destroyed precious wooded areas and have displaced the wildlife that called the property protection and home. Now we are again burdened with another company that will continue this pattern. The statement was made that there is a need for more businesses along this roadway, and we do not understand the aspects of growth like the engineers and attorneys. Fact is, the storage company was forced on our neighborhood. Publix, the bank, Dunkin' Donuts are all almost 4 miles south, and local restaurants are small mom and pop owned. And the Walgreens was an old Barnett Bank building. So this argument is basically moot. There's nothing wrong with slowing down growth when it affects or will harm to animals as well as humans. Nationally, it is a concern that small businesses are going under due to these multi-billion-dollar businesses. A half-mile south of this property is a Blessings gas station and convenience store, a hardworking American who built his business over many years. This possibly proposed 7-Eleven could put them out of business. First, consider that the upcoming road construction, it'll have 2 lanes turning south from Sunset Lane onto Highway 41, completely missing the proposed 7-Eleven. Not far from this area, a short 5 miles away, is Barrison, Florida Avenue. At Barrison, Nebraska is a Wawa. These 7-Eleven type businesses service most of the vehicles that enter and exit I-275 at Bears. They then proceed north on 41 and will quickly pass the proposed 7-Eleven. Consider the loss of safe haven for our wildlife, the businesses that will be destroyed, the traffic, the noise during late hours, the pollution, the fuel pumps, containers that eventually will leak into the ground, contaminate the soil, wells, and aquifer. I also worked for an engineering firm, so I do understand this. Yale University, CETO Lab, Environmental Impacts of Urban Growth. Recent findings. The conversion of Earth's land surface to urban uses is one of the most irreversible human impacts on the global biosphere. It hastens the loss of highly productive farmland, affects energy demand, alters the climate, modifies hydraulic and biochemical cycles, fragments habitats, and reduces biodiversity. We see this effect on multiple levels. Future urbanization will, as example, pose direct threats to high-value ecosystems. The highest rates of land conversion over the next few decades will likely take place on biodiversity hotspots that were relatively undisturbed by urban development in 2000, CETO et al. 2012. Findings reveal urban expansion will affect global climate.
That's the end of your time, but I'll allow you to wrap it up if you could.
Thank you. I just have a couple of paragraphs.
Perfect.
Direct loss in vegetation biomass from areas with high probability or urban expansion is predicted to contribute about 5% of total emissions from topical deforestation and land use. The U.S. government, U.S. Fish and Wildlife Service Biology, Anthony Ford declared on September 29, 21, the ivory-billed woodpecker and 22 more extinct birds. Florida, Arkansas, Louisiana, and Mississippi were habitats to some of these birds. The flat pigtoe, a freshwater mussel in the southeast, were never seen again. These are facts that are undisputable. I respectfully ask the hearing master and the county commission to look at these intent studies and deny the proposed construction of the subject land that is rich in nutrients and protection for the delicate lives that are in danger. Thank you so much.
Thank you for coming down. If you could please sign in, and if you'd like to submit that into the record, you're more than welcome to. Yeah, you have to be on the record though, just real quickly, and then we're going to close opposition testimony.
Thank you, Your Honor. I'd like to point out,
Give us your name just real quick.
Sam Calco again.
Thank you.
Thank you. I would just like to point out those that are here tonight in opposition. Not all, everybody could come due to work and illness, but if those in opposition would also just stand up, please. Thank you so very much.
Thank you so much. So with that, we'll close opposition testimony. Development Services. Anything else, Mr. Grady?
Nothing further.
All right. Then Ms. Corbett, you have on the books 5 minutes for rebuttal, but I gave everybody a little extra time, so
Plus I
I'll
had
allow that.
7.
Yes,
Plus I
go
had
ahead.
7 from before.
Yes.
Hopefully I won't need all that time.
I hope you won't.
If I could, I did not catch this woman that just spoke. She indicated that she worked at these companies. Can we ask her in what capacity she worked at those
Absolutely.
companies? She's right over here
Oh,
signing
yes.
in.
We have to be on the record.
Yeah, if you could,
Yeah.
Come on,
You have to be on the microphone. And when you go back,
and just if you could,
identify
the
yourself.
position that you held.
And give us your name to start.
Administrative assistant, I assisted all of the engineers in their putting together all their proposals and their findings on different roadways and the traffic congestions.
And your name again?
Susan Guess.
Thank you so much. I appreciate it. Go ahead.
Thank you. I just wanted clarification for the record because I just wanted to gauge level of expertise. Couple of things. First of all, as far as compatibility, Development Services staff and the Planning Commission have looked at this 2 times now under all the circumstances, take into consideration all of the plan policies, including the Lutz Community Plan. And this is part of a community planning effort, and the Lutz Community Plan specifically identifies this intersection as appropriate for commercial. And as we talked about in the last hearing, there are parts of the Lutz Community Plan, the downtown district in particular, that says and prescribes only these uses can go in this location. That's not applicable here. So this is within the scope of appropriate uses. It's low intensity. I think I submitted the BOCC transcript, which is already formally in the record, but I wanted to submit it to you so you can review for yourself the scope and level of the concerns. The vast majority of the environmental concerns that were raised at that hearing related specifically to the car wash and how that would interface with the wetland system. And as you've heard, we have removed that from consideration. And I think that the testimony that you've heard this evening is very similar to the testimony we heard at the last hearing. And already in the record is the testimony and evidence from Mike Alfieri and Joshua Blanco, who are certified experts in this field of both hydrology and also underground tank storage. And I don't think we've heard any expert testimony that would undermine anything that they heard. And I think that our record stands on those topics. And I would like to ask Dale Merriman to come up and address a little bit more of the wetland issue, since that is new to this record.
Thank you.
Yes, Dale Merriman, again for the applicant. I'll try to make this as brief as possible to answer the 5 different issues that were brought up. One thing in particular, when they mention about the forms at wetland delineation forms, these are used by everybody. It is the new law of the land. It follows Florida Administrative Code 62340. So you can't just dismiss those because it is the methodology that everyone that is experts in the field and or agency people use to determine the wetlands. There is not going to be any impact to the wetlands from this particular operation. A second part of this is that those that have familiarity with systems such as we're talking about now, new rules went into play 10 or 15 years ago that required double wall tanks, double wall piping, and there's a thing called interstitial monitoring, which automatically, if there's any leak from the main pipe into the other pipe, it automatically shuts everything down. Not only that, but the pumps and the dispensers, they have secondary containment as well, and they're also on an electronic release detection. So basically, when we're talking about these tanks, these are the state of the art. These are the ones that the state has required. That's why in a few years back, you saw so many fuel tanks being removed because they were the old steel that had rusted. So there's plenty of compliance with what is required by the government. I'm a petroleum contractor, so I'm familiar with these issues. One other mention was on the potable wells. I believe it was mentioned in the last time at Crystal Lakes Manor, they had 2 wells, potable wells. Those have since been abandoned, so they're no longer in play. And the county, of course, has extended potable drinking water distribution systems. When we checked, there were no potable private wells within 500 feet of this particular project, with the groundwater going towards the southeast. Finally, addressing the listed species, the report was completed on that in September of 2020, and there were no indications of any endangered species on site, nor is there the type of habitat that they would use. And that has already been taken care of as well, either when we looked at the entire site in its entirety. Thank you, ma'am.
Thank you so much. Ms. Corbett.
And so the standard of review, the legal standard review of when lay testimony is allowed is actually contained in a memorandum that's already in the record that you have. And I'd ask you to defer to that and refer to that when you deliberate and consider Mr. Forgy's testimony about what the state of the law is on those topics. Expert testimony is required, particularly when it comes to compatibility. So we would, again, direct your attention to that. And unless you have questions that were raised by the opposition regarding the transportation, I think we'll conclude our presentation and rest on our record.
No, I don't have any further questions. Thank you. Thank you so much. Then with that, we'll close rezoning 20-1253 and go to the next case.
The next item is agenda item C3, rezoning standard 22-0580. The request is rezoned from RSC4 AS1 to RSC4 with a mobile home overlay. Isis Brown will provide staff recommendation after presentation by the applicant.
Good evening.
Good evening, Isabel Albert with HAF, 1000 North Ashley Drive, Suite 900. I'm here representing the applicant, and I have a presentation for you. Next, please. So the 11.5 acre site is located in Tonosasa, more specifically at the southeast corner of County Road 579, also known as Manga Road and Pruitt Road, and it is also located in the rural service area. Next, please. Surrounding zoning is quite a hodgepodge of it. The brown area is the residential 4 with a mobile home overlay that you'll see along Manga Road. You'll also see the red area, which is commercial, and the big portion of there on the west side is the Cascrete, just to give you an idea. The blue areas are the planned development zoning. The one on the east side is approved for manufacturing, about a little bit more than 400,000 square feet of manufacturing. And to the west side, that's the Lazy Days service and sales and RV service there. The green area, you'll see a light green area on the east side of Manga Road, and that's the Hillsborough County Household Hazardous Waste Collection area. And on the west side, you'll see more of the residential portion of it. And the future land use is residential 4. Next, please. So the request is to rezone the site to an RSC4 with a mobile home overlay, similarly to the site to the east. But it is located in the rural service area, and therefore they cannot connect to the water and sewer along Manga Road, and therefore they're required to have a half-acre lots. Next, please. And recommendations, there was no objections from reviewing agencies. The planning development services staff found it compatible with the area, and the planning commission staff found the request consistent. And I'm here if you have any questions.
No questions at this time, but thank you.
Thank you.
Development services.
Good evening, Development Services, Isis Brown. The request is to rezone from the existing agricultural single-family residential and which is RS1, residential single-family conventional 4, RSC4, to the proposed RSC zoning 4 with a mobile home overlay. The proposed zoning RSC 4 with mobile home overlay permits single-family conventional and mobile home development on lots containing a minimum of 10,000 square feet. The site is located in an area which comprises a mixture of uses, including agricultural, single-family, residential uses, and the planned development. Yes, I am. Sorry. With business, professional, office uses, and commercial general uses. The immediate surrounding area consists of properties within the Res 4 future land use category to the north, south, east, and west. The Res 4 future land use category has the potential to permit agricultural, single-family, residential, and some commercial office and multi-purpose uses. The subject property is surrounded by property zone AS1, RSC 4 with mobile home overlay, and CG to the north and south. To the east, properties are zoned, there's the County Road 579 and RSC 4 with mobile home overlay, and a PD 031308, which has a BPO type use. And to the west, properties are zoned AS1 and RSC 4 with mobile home overlay. The site is located in a rural service area and outside of the Hillsborough County urban service area, and therefore will have to have a minimum of, will require septic and well, and will require a minimum of 0.5 acres. The size and depth of the subject parcel in relation to other adjacent residential uses will create a zoning development pattern that is consistent with the existing zoning and development pattern of residential uses zoning districts in the area. Based on the above recommend conditions, staff find the proposed RS4 with the mobile home overlay zoning district is compatible with the existing districts and development pattern in the area, and staff finds the request approvable. I'm available for any questions.
No questions at this time, but thank you so much. Planning Commission, please.
Carliano, senior planner with Planning Commission staff. The subject site is within the rural area and is within the limits of the Tono-Tasasa Community Plan. The parcel has a future land use designation of residential 4. The applicant is requesting again to rezone the property from agricultural single family AS1 and residential single family conventional 4 RSC 4 with a mobile home overlay to residential single family conventional 4 with a mobile home overlay. The intent of the residential 4 future land use category is to provide for areas that are suitable for low density residential development. The residential 4 land use designation allows up to 4 dwelling units per the acre. However, the rural area limits lot sizes to half-acre minimums. The maximum units allowed on this site would be 22 units. The applicant's revised narrative submitted May 2nd, 2022 states that 10,000 square foot lots are being proposed. Since the property is located in that rural area, the applicant is required to build 21,780 square feet or half-acre lot at the minimum. Compliance with this requirement is essential to the proposed rezoning being consistent with the future land use policies 9.2 and the One Water Objective 4.3 and policies 4.3.2, 4.3.3. Therefore, the proposal meeting the minimum half-acre lots is consistent with Objective 12 and all the applicable policies stated in the report, and is also consistent with Objective 16 of the community design component. Overall, staff finds that the proposed half-acre lot sizes and the RSC4 zoning would provide compatible lot sizes and densities within the rural area and supports the vision of the Tono-Tasasa Community Plan. Proposed rezoning would allow for residential development that is consistent with the goals, objectives, and policies of the future land use element of the future of Hillsborough County Comprehensive Plan for the unincorporated Hillsborough County. Based upon those considerations, Planning Commission staff finds the proposed rezoning standard consistent with the future of Hillsborough Comprehensive Plan and the unincorporated Hillsborough County. I will stand if you have any questions.
No questions at this time. Thank you so much. I'll call at this point for anyone that would like to speak in support of this application. Anyone want to testify in support in the room or online? No one? Anyone in opposition to this request? Seeing no one in the room, no one online. Mr. Grady, anything else?
Nothing further.
All right. Ms. Albert?
Nothing further.
All right. Ms. Albert?
Nothing further.
Nothing? All right. Then with that, we'll close rezoning 22-0580 and go to the next case.
The next item is agenda item C4, rezoning standard 22-0690. The applicant's Brooklyn Law Group. The request is rezone from RSC 6 to M in manufacturer zoning district. Isis Brown will provide staff recommendation after presentation by the applicant.
Good evening. There
Good
you go.
evening.
Yep.
Clayton Bricklemeyer Law Group, 4427 West Kennedy Boulevard. I don't really have much of a presentation. This is a piece that's left over. Everything around us is M, and we are basically bringing it in line. I'm available for questions and would ask for your recommendation.
No questions at this time, but thank you. I appreciate it. If you could please sign in with the clerk's office. Development Services.
Isis Brown, Development Services, case number 22-0690. The request is to rezone from an existing residential single-family conventional 6 RSC 6 zoning district to the proposed manufacturing M zoning district. The proposed zoning for M permits manufacturing, processing, or assembling uses, intensive commercial uses, and other industrial uses on lots containing a minimum of 20,000 square feet. The acreage of the property is 0.68 more or less acres. At its current standing, it's one dwelling. The density and intensity is 1 dwelling unit per 7,000 square feet. The proposed zoning will, based on the manufacturing, has a FAR of 0.75, and the mathematical maximum would be 22,215 square feet of development. The site is located in an area comprised of light industrial, mixed, and commercial uses. The adjacent properties are zoned manufacturing to the north, south, east, and west. Subject sites immediately surrounding the area consist of properties within the urban mixed use 20 future land use category to the north, south, east, and west. The overall area is also within the urban service area with publicly owned and operated potable water and wastewater facilities available. Thus, the proposed zoning is consistent with the surrounding development pattern. The size and depth of the property in relation to the other adjacent commercial uses would create a zoning development pattern that is consistent with the existing zoning and development pattern of light industrial and commercial uses zoning district in the area. Based on the above consideration, staff finds the proposed M zoning district is compatible with the existing zoning district and the development pattern of the area. Staff finds this request for proposed M zoning approvable. I'm available for any questions.
No questions at this time. Thank you. Planning Commission, please.
Carliano, Senior Planner of Planning Commission staff. The 0.67 acre subject site is located in the urban service area. It is also located within the limits of the Brandon Community Plan in the light industrial character district. The subject site's future land use designation is urban mixed use 20 on the future land use map. The subject site is zoned residential single family conventional 6. It is surrounded entirely by manufacturing zoning districts. Planned developments are located to the west across Falkenberg. The applicant is requesting to rezone the subject site from residential single-family conventional 6 to manufacturing. The proposed rezoning to manufacturing would maintain a light industrial character of the area, as there are already a number of manufacturing zoning districts within proximity. The site is in the urban mixed-use 20 future land use, which anticipates higher intensity uses, which are inclusive of light industrial uses, and the proposed rezoning therefore meets the intent of Objective 8 and policies 8.1 and 8.2. Objective 9 and policy 9.2 require that all developments be consistent with the plan and meet all the land development regulations in Hillsborough County. Because the surrounding land use patterns have already transitioned to more intense manufacturing character, the proposed rezoning is compatible with the character of the area. The request is consistent with the Brandon Community Plan. The site is in the light industrial character as previously mentioned, and it's also outlined in Goal 6, 5C, and therefore meets the intent of the character district. Overall, the proposed rezoning would allow for development that is consistent with the goals, objectives, and policies of the Future of Hillsborough Comprehensive Plan for the unincorporated Hillsborough County, and is compatible with the existing and planned development patterns found within the surrounding area. So based on these considerations, Planning Commission staff finds the proposed rezoning standard consistent with the future of Hillsborough County Comprehensive Plan for the unincorporated Hillsborough County. And I'll stand if you have any questions.
None at this time, but thank you. Is there anyone in the audience or online that would like to speak in support? Anyone in favor? Seeing no one. Anyone in opposition? No one online. Anyone in the room? Okay. No one. Mr. Grady, anything else?
Nothing further.
Mr. Bricklemeyer, anything else? All right, then with that, we'll close rezoning 22-0690 and go to the next case.
Next item is agenda item C5, rezoning standard 22-0697. The applicant is AMQ International Corporation. The requester is rezoned from planned development and ASC1 to commercial general. Chris Grandelar will provide staff recommendation under presentation by the applicant.
Good evening.
Thank you. Good evening, Hearing Officer Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. This is AMQ International Corporation. It's the existing plan development 860193. Seeking proposed zoning as commercial CG for the entire parcel to allow general commercial office personal services. Zoning Department is in support. Planning Commission is in support. We haven't heard any opposition on the request. This is a 3.82 acre property, consists of two parcels. Zone PD and the other is AS1, located across from Lakewood Drive. If I may just put this up real quick here.
Turn on the microphone there. Yes.
Thank you. This is East Broadway in Lakewood. One parcel, Zone PD, is here. This is the second parcel. Per zoning.
Mr. President, is that graphic upside down? Sorry, or upside down to me, perhaps?
Let's see.
There you go.
That might be better. Okay, there we go. So Broadway in Lakewood, this is the PD parcel. This is the second parcel. I'll put this in the record. And this is the original PD. Planning Commission finds the proposed uses consistent with comprehensive plan surrounding uses zoning to the northeast and southwest are similar to the request, commercial. Also, some of the parcels are on a minor arterial roadway, which is conducive to high levels of commercial traffic. The Planning Commission also notes that it is in conformance with the community plan and is also in the urban service area, and which is the Sefton-Mango Community Plan, supports infill development, and that it would provide serving uses to facilitate growth in the urban service area, and again, supports the community plan. Be happy to answer any questions you might have.
None at this time, but thank you.
Thank you.
Development Services.
Good evening. Let me bring up my PowerPoint. Okay, Chris Graulenard, Development Services, speaking for application 22-0697. It's application to rezone from existing PD 860193 and agricultural single-family conventional zoning district to the proposed commercial general zoning district. The approximate 3.82 acre property is comprised of two parcels as located at the northwest corner of Lakewood Drive and East Broadway Avenue. It's located in the urban service area and the Sefton-Mango Community Plan area. The future land use is residential 9. Res 9 is to the northeast and west, and residential 6 is to the south across East Broadway. Max density of 9 dwelling units per acre, or 0.50 floor area ratio. The current zoning classification, again, is PD 860193 and agricultural single-family conventional. Zoning district immediately to the north is ASC 1 and PD 860193. Zoning district to the west is RSC 6 and to the south ASC 1. And to the east is commercial general and RDC residential duplex conventional 12. The approximate 3.82 acre property is comprised of two parcels. With folio 65719 is zone PD 860193. The 0.54 acre parcel with folio 65720 is zoned ASC 1. The subject parcel is located at the northwest corner of Lakewood Drive and East Broadway Avenue within an area comprised of single family and two-family residential and commercial. The subject parcels are directly adjacent to vacant commercial zoned PD 860193 and vacant residential zoned ASC 1 to the north. Single-family residential homes zoned RSC 6 are located across Hibiscus Avenue to the west. Vacant commercial zone CG and vacant residential zone RDC 12 is located across Lakewood Drive to the east. Also, single-family mixed-use zone ASC 1 is located across East Broadway Avenue and the CSX railroad tracks to the south. The subject is residential 9 on the future land use map, and the Planning Commission found the proposed use consistent. The surrounding uses and zoning to the northeast and southwest are similar to the request, commercial. Also, the subject parcels are located on East Broadway Avenue, State Road 574, which is a minor arterial conducive to higher levels of commercial traffic. Therefore, the rezoning of the subject parcel from PD 860193 and ASC 1 to commercial general CG would be consistent with the existing zoning pattern of the area. Also, just as a side note, buffering and screening is in accordance with the Land Development Code will be required along the western boundary, as Hibiscus Avenue right-of-way along the western boundary is less than 50 feet in width. Therefore, for purposes of buffering, screening, the parcel is considered adjacent to the residential west of the parcel. Also, a personal appearance modification to PD 86-0193, removing the parcel from a planned development is currently pending. Again, the applicant, based on the residential 9 future land use classification, their surrounding zoning and development pattern, and the proposed uses for the CG zoning district, staff finds the request approvable. Be glad to answer any questions you have.
No questions at this time, but thank you for your testimony. Planning Commission.
Carla Llanos, Senior Planner with Planning Commission staff. The subject site is 2 parcels located on approximately 3.82 acres. The site is in the urban service area and within the limits of the Seffner Mango Community Plan. The site has a future land use designation of residential 9. The applicant requests to rezone the 2 parcels from agricultural single family conventional 1 and PD, planned development, to commercial general. The property is consistent with objective 1, which directs growth within the urban service area. The proposed rezoning also meets the intent of objective 16 and 22 and all the other applicable policies. The subject site is within the required 1,000 foot distance from the closest qualifying intersection, which is East Broadway Avenue and Lakewood Drive. It meets commercial locational criteria. The subject site meets the intent of the Seffner Mango Community Plan. The plan has the goal of enhancing community character with quality residential and non-residential development. So this request actually supports infill development within the urban service area that is compatible with the surrounding uses. Planning Commission staff determined that the property is not encroaching into a residential area, therefore is considered non-residential infill. Overall, the staff finds that the proposed commercial general zoning district would allow for the neighborhood serving uses. that would facilitate growth within the urban service area and supports the vision of the Sefner Mingo Community Plan. The proposed zoning would allow for the development that is consistent with the goals, objectives, and policies of the future land use element. And the request is considered compatible with the existing development pattern found within the surrounding area. So based upon those considerations, Planning Commission staff finds the proposed rezoning standard consistent with the future of Hillsborough Comprehensive Plan for the unincorporated Hillsborough County.
Thank you so much. I appreciate it. Is there anyone in the room or online that would like to speak in support? Seeing no one, anyone in opposition to this request? No one in the room, no one online. Mr. Grady, anything else?
Nothing further.
Mr. Pressman? Anything further? All right, then with that, we'll close rezoning 22-0697. I think normally we take a break at 8 o'clock, but we'll do one more case and then we'll take the break at the conclusion of this case.
The next item then is agenda item C6, rezoning standard 22-0699. The applicant's Brooklyn Minor Law Group. The request is rezoned from AR to AS 0.4. Isis Brown will provide staff recommendation after presentation from the applicant.
Good evening.
Good evening, Ms. Finch. Clayton Bricklemeyer Law Group, 4427 West Kennedy. Again, I don't have much of a presentation. We're going down to AS 0.4, which keeps us a 2.5 acre lot minimum. That's to allow for subdivision. Hadn't decided exactly what it looks like, so we're sticking with Euclidean. We believe it's compatible, and I'm here for questions.
None at this time. Thank you so much. If you could please sign in.
Will do.
Development Services.
Isis Brown Development Services, case 22-0699. The request is to rezone from the existing agricultural rural AR zoning district to the proposed agricultural single-family estate AS 0.4 zoning district. The proposed zoning for AS 0.4 permits, single-family conventional. Sorry. Ooh. Conventional home development in low density rural environmental areas encourages agricultural activities and supports the minimum lot size in the AS 0.4 zoning district is 2.5 acres. The subject property is 8.45 acres with a density intensity of 1 dwelling unit per 5 acres. Currently, the proposed will be 1 dwelling unit per 2.5 acres. The site is located in an area comprised of rural agricultural and rural low-density residential area. The adjacent properties are zoned AS C1 agricultural, single-family conventional residential, and AR to the north, AR to the south, ASC1, AR, and the Fourth King Highway to the west, and Lake Tanasasa to the east. The surrounding area consists of properties within the Res 1 future land use category and permits agricultural and single-family residential uses. The site is located outside the site is located outside the urban service area. The site is located and therefore, God, what is wrong? The subject property will be served by private well water and septic for wastewater. The size and the depth of the subject property in relation to the adjacent agricultural and single-family uses would create a zoning pattern and development that is consistent with the existing zoning and development pattern of the agricultural and single-family uses and zoning district in the area. Based on the above considerations, staff finds the proposed AS 0.4 zoning district is compatible with the existing zoning district and development pattern in the area. Staff finds the request approvable. I'm available for any questions.
It sounds like you made it through to the end, so we'll give you some time for water. So thank you. No questions at this time. I appreciate it. Planning Commission, please.
Carliano, Senior Planner with Planning Commission staff. The property is 8.47 acres and it's located within the rural area and is within the limits of the Tohono-O'odham Community Plan. Property has a future land use designation of residential 1, and the area is predominantly within this category as well. The applicant is requesting a rezoning from agricultural rural to agricultural single-family estate dash 0.4 to allow for an additional dwelling unit. The site is currently developed with single-family residential homes and a guest home. The subject site has access from Knight Griffin Road through Old Fort Trail, which is an unimproved right-of-way. Per Objective 4, the rural area is intended for agricultural uses and large lots, low-density rural residential uses. The residential 1 future land use category would allow for a maximum of 8 dwelling units. However, the request is to allow for only 1 additional unit, creating an average lot size of 4.2 acres approximately, which is comparable with the large lot, again, low density rural residential uses or character of the surrounding area. The proposed development meets the intent of the Tohono-O'odham Community Plan. Overall, the proposed rezoning is consistent with the goals, objectives, and policies of the future of Hillsborough Comprehensive Plan for the unincorporated Hillsborough County, and is compatible. It is a compatible use with the surrounding rural residential area. So based upon those considerations, Planning Commission staff finds the proposed rezoning standard consistent with the future of Hillsborough County Comprehensive Plan for unincorporated Hillsborough County. So he's a handful.
Thank you so much. I appreciate it. All right. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one. Anyone in opposition to this request? Seeing no one. All right. Mr. Grady, anything else?
Nothing further.
Mr. Brickemeyer? Nothing. All right. Then with that, we'll close rezoning 22-0699. We're going to take a short 5-minute break. Oh, excuse me. I didn't see you. Oh, we asked for opposition. I apologize, but if we can reopen the hearing to provide your testimony if we missed it. All right, let me just do it for the record. So let's reopen rezoning 22-0699 to take a gentleman in opposition, his testimony. Before we do, is there anyone else that wants to speak in opposition to this request? Seeing no one. All right, if you give us your name and address, please.
Sure. My name is Jeff Marple, 12401 Calusa Lane, Tohono-O'odham. I'm Alex's northernmost neighbor. We'd like to go ahead and support the staff recommendation. The request was put in this comes off of the report. The request is to allow for additional dwelling unit, creating an average lot size of 4.2 acres, which is comparable with the large lot, low density rural residential uses of the land surrounding area. As you go down further down into your recommendations, it talks about that the average lot size would be 4.5. So this is a difference of where we were at from what Mr. Brickemeyer was saying about 0.4. Your recommendation is saying it's willing to go forward as long as we have an average lot size of 4.5. The flu report says 1 home per 1 acre in the future. This is not a residential development. These are large lots on a very private lake. To her northern point, we have a 5-acre lot. To her southern immediate neighbor, there's over 40 acres. And then it goes 5, 5, 5, and then another 20-acre lot. So all I am asking, and we're willing to accept and approve, that the average lot size that with the original request was 4.2, and that the average lot size stay at 4.5.
So just to be clear, your lot is the abutting lot to the north?
Yes.
And how large is your property?
5.
5 acres. I see. All right. Does that complete your testimony?
It does. Thank you so much.
If you could please sign in with the clerk's office. Now, let me have Mr. Brickemeyer the opportunity for a rebuttal since we reopened the case.
Thank you very much. Clayton Brickemeyer again for the record. I actually know what Mr. Marble's talking about. I believe the Planning Commission report talks about like it's as if it were a PD. It is not a PD. It is, we're asking for Euclidean zoning that would get us to 2.5 acre lots. That's the minimum. We would be able to subdivide obviously into 4 acre lots. I am going to put up from the staff report. Did it happen? If you just look around the lake, Mr. Marple and I think just disagree about the diversity of the sizes of the lots. I think 2.5 acres, if you look around the lake, is a completely appropriate size. If we went to that size, which we're not guaranteeing that we are, we're just giving ourselves some flexibility. Staff agrees and the planning commission agree that it's appropriate. I agree with them.
Let me ask you a question for the record.
Yes.
So the acreage on the agenda is noted at 8.45 acres.
Yes.
If I understand you haven't subdivided this out to find out exactly where you want to be, but given that, what do you believe is the maximum number of lots?
3. There's no more than 3.
3 at
Yeah.
2.5 acre. minimum.
Correct.
I see.
And that honestly is going to be a struggle because of the way the driveway works. So
That was my question,
more than
where they would
likely
be
it's going to
accessed.
be 2, but we're trying to build in enough flexibility to have 3 for family reasons. That's the reason.
All right. And then the other question, just to confirm for the record, is you're not asking for any variances or anything. They will adhere to the access requirements and so forth.
Correct. Yes. Everything in the code that's attached to AS.4 we're adhering to.
Understood. Okay.
Yes, ma'am.
Thank you so much.
Thank
Then
you.
with that, we will close rezoning 22-0699. And now we'll take a 5-minute break. So I have, what time is it? It's 8:10, so 8:15. We'll be back online. Thank you so much. All right, good evening. We are back from our break for the May 16th, 2022 zoning hearing master hearing. So, Mr. Grady, let's call the next case.
The next item is agenda item C7, rezoning standard 22-0702. The applicants are Jose R. and Pedro J. Rodriguez. The request is to rezone from agricultural single-family conventional 1, which permits a minimum lot size of 1 acre, to commercial neighborhood, and the applicant is proposing restrictions, so it'll be commercial neighborhood with restrictions. Chris Grandin will provide staff recommendation after presentation by the applicant.
All right, before the applicant begins, we did have a number of people come in the room after the break. So if you plan to speak tonight, and if you could just turn off your cell phones, if you plan to speak tonight on this case or any other case on the rest of the agenda, and you have not been sworn in, if you could please stand and raise your right hand and I'll swear you in. If you're online as well. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you so much. All right, please proceed with the applicant. Good evening.
Good evening, Hearing Officer Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. This is a 4.61 acre lot located 6400 Hartford Street. Currently zoned SC1, seeking CN-R restricted. And I do have a PowerPoint for you. Thank you. Rezoning standard 0702. Next slide, please.
You said you were adding the restriction. That first slide didn't have the restriction on the.
That would be my error. It is restricted.
Okay.
And there are several restrictions which I'll list for you. Thank you for catching that.
No problem.
We are in the greater Palm River area. Next slide, please. And looking a little closer, 6400 Hartford Street, Tampa. Next slide, please. This is as the property appraiser has it. Next slide, please. So surrounding uses, on one side is the school, although it's located further away. There are some very heavy industrial type uses: Bulk Express, Premier Trailer Leasing, Eagle Transport Corp., and S&S Freight. Those are uses in the immediate vicinity that are operating. Next slide, please. Under zoning, the site is in purple. CI zoning is located across the street. A large swath of manufacturing zoning is located across the street. There's some CI and M further down the street on Hartford. Next slide, please. Under future land use category, a very large area is light industrial with a couple SMU 6s in the immediate vicinity. Next slide, please. So as indicated, it's a 4.61 acre lot, ASC1 to CNR. We have a number of restrictions which are in direct response to concerns raised by the staff. The first is the use restricted to an outdoor and indoor venue, banquet, reception use facility. And Mrs. Soto is here with her niece, correct? And she'll speak in a few minutes. This is their family business. All the family works in different capacities on infrequent uses or on a frequent use that they have. The events in the property, restriction number 2, events in the property will only occur on Friday, Saturday, and Sunday. Friday events would only occur after school hours. Next slide, please. Third restriction is the existing fence of which surrounds the entire property must remain in place. And 4 events are between 4 p.m. and midnight other than lights setting up the event and cleaning up the event. Next slide, please. So the main access to the site is on Hartford, but I think it's important to note that the school main access is on the roadway very far to the north. You can see how the school is oriented that direction, and the main access, again, for the school is not interfered with or imposed with access to this site. Next slide, please. So again, this is a close-up of the school. You can see all the activity, traffic, orientation of school is strictly on 36th Avenue South. Next slide, please. Another important feature is U.S. Fish and Wildlife Wetlands Mapper showing the site, and next door is a wetland area, so it provides a significant buffer and separation. Even though there's nothing on the school grounds there, provides a natural thick wild buffer between the two. Next slide, please. And there's a fence surrounding the property. You can see that by the aerial. Next slide, please. We do have a budding neighborhood support to demonstrate to you. Next slide, please. We have support surrounding the site to the north and on the west on the other side. Next slide, please. This is the one property owner who signed the letter in support, and they are supportive of the use. Next slide, please. And this is the other owner who is also supporting the site. Next slide, please. The locational waiver filed, we've addressed that by the geographical and operational elements that I've indicated to you. We have great buffering and fencing. Obviously, the restrictions are pretty widespread per use and also the infrequent operational times. We talked about the orientation of the school, the widespread nature of the area, and intensive uses and zoning in the immediate area that are located. Next slide, please. Staff means concern, as I have them and as I've had some communication with them, was compatibility with the residential. We've documented their support very clearly to you here. And secondly, noise or issues emanating from the site to the school. We've clearly documented restricted no school hour activity whatsoever. Next slide, please. So in summary, there's intensive zoning, future land use categories in the immediate area, right across the street, wide swaths of it, extensive and far-reaching restrictions, and abutting uses are either in support or have been addressed at zero impact. With that, I'd like to ask Ms. Soto to come up, if you would, please. She does have a series of pictures here that I'd like to show you. And she has a few comments, but I'd like to lay these out for you. If we go to the overhead, please. These are just some of the pictures to show you the use. You had one of these, though, didn't you? Yeah. Yeah. Yes.
Mr. President, is this an existing use?
Yes, I actually should have clarified that. Yes, this is an existing use. It's been in use for actually a number of years. As the Sotos started communicating and interfacing with the county to be getting permits and be getting usages or use permits or permissible use permissible activity, they moved forward with the county, and at one point, the code enforcement office made them aware that there was a use that was not permissible with zoning. However, when I checked today, I don't know why, it showed that case has been complied with. I don't have an explanation for that. But yes, this site has been in existence, and per the zoning, it's not permissible, and that's why we're here today.
I see. Thank you.
I really should have clarified that up front. I'm sorry.
All right. Please continue.
So a lot of and we'll put these in the file, a lot of these are, most of these are interior, small, most of them are interior, but they're all small in nature. A lot of it's local families, local groups, some of their own family, which I've been told is quite large. But just to give you a flavor of, this is a smaller use. It's not very active. It's not very loud, not very involved, not very impacting. Again, small in nature.
Is that an existing single-family home what is the structure on the building, on the property?
It's a clubhouse.
It's just a simple clubhouse.
I see. And we'll need your name and address on the record.
Yeah. If you want to go ahead and make some comments.
Juana Soto, 4103 North Havana Avenue, Tampa 33607.
All right. And you've operated the business?
We've owned the property for about 45 years. My parents have. We've done all family events there, Christmas, christenings, New Year's. In the last couple of years, we've been doing small events, not knowing that it had to do with the zoning. So that's why we're here today, to try to get it rezoned my parents are both retired, so it's a source of income for them. So the property has a clubhouse, and that's the only structure on site? There's a bathroom, and then just like an overhang, and like little, yeah, it's like a
picture.
barbecue pit area.
I see.
But the only structure itself is the one clubhouse.
Does anyone live on the property?
No.
I see.
No.
Okay. Go ahead with your presentation. I didn't mean to interrupt.
I think that pretty much sums it up. The only other point I'll make is that they've had the test of time. zoning wise or not. They've had the test of time for a number of years. There's been no complaints filed. So in that regard, they've been operating and it has not been an imposition by the school. I did receive a couple emails from the school just asking me what the request was about. I don't know if they're here today or if there's anything in record, which I answered. They didn't seem to have the gentleman didn't seem to have any difficulties. But again, I think it is important to note that it has been operating and has not been a difficulty that we're aware of.
And you don't know how the code enforcement became aware of it?
Code enforcement became aware as Ms. Soto was integrating or interacting with the county for permits as she was moving forward. And it eventually became, they eventually became aware that there was a difficulty with the zoning.
I see. Okay. Does that complete your presentation?
Yes, it does.
All right. Thank you so much. Thank you. And if you could both sign in with the clerk's office, I'd appreciate it. Development Services, please.
Good evening again, Chris Kraunar, Development Services. Okay. I'm here to present case number 22-0702. That's a rezone from an existing agricultural single-family conventional to proposed commercial neighborhood restricted. It's on a approximate 4.61 acre lot located at 6400 Hartford Street. It's in the urban service area and the Greater Palm River Community Plan area. The future land use is residential 6. Res 6 is to the north and east. Public, quasi-public is to the east. That's where the school is. Light industrial is to the south. The maximum density is 6 dwelling units per gross acre or 0.25 FAR. Again, the current zoning is ASC 1. To the northeast and west is also ASC 1. And immediately to the south is a manufacturing. That's where the trucking company is, across Hartford Street. The approximate 4.61 acre lot is located 6400 Hartford Street. Parcels in an area comprised of single-family residential, light industry, commercial, and institutional. The subject parcels are directly adjacent to residential zone ASC 1 to the north and west. To the east, the parcel is adjacent to an elementary school, zoned ASC 1. To the south, across Hartford Street, is a trucking company zoned manufacturing. The applicant has offered the following restrictions to mitigate compatibility concerns. 1, the use is restricted to an outdoor and indoor venue, banquet, reception use facility. 2, events in the property will only occur on Friday, Saturday, and Sunday. Friday events would only occur after school hours. Number 3, the existing fence of which surrounds the entire property must remain in place. Number 4, events are between 4 p.m. and midnight, other than setting up the event and cleaning up the event. The applicant also requested a waiver for commercial locational criteria. It's located in policy 22.8 of the comprehensive plan. The subject property is R6 of the future land use map. The Planning Commission found the proposed use inconsistent with the comprehensive plan, noting the following: subject site does not meet commercial locational criteria as per objective 22 and policy 22.2 of the future land use element. The applicant has requested a waiver, which is in the record. The site, number 2, the site is not located at a designated commercial node recognized by the community plan. 3, the Planning Commission staff have compatibility concerns with the proposed use and the residential uses to the west. Staff also noted that the site is adjacent to a school on the east side, and noise emanating from outdoor events are a concern. Zoning staff also has concerns The reception facility, even with the restrictions, would adversely impact the adjacent residential to the north and the west of the parcel, given that activities will be occurring on weekend nights. The facility appears to be inconsistent with the character of the area on the north side of Hartford Street. Based on the residential 6 future land use classification, the surrounding zoning and development pattern, and the proposed uses for the commercial neighborhood restricted zoning district, staff finds the request not supportable. I'll be glad to answer any questions you may have.
Just one quick question. Was it ever considered for this application to be in discussions with the applicant or the representative to be rezoned to a planned development instead?
It was not discussed.
All right. Thank you so much. We'll go to the Planning Commission, please.
Carliano, Senior Planner of Planning Commission staff. The property is approximately 4.66 acres, and it is located within the urban service area and is within the limits of the Greater Palm River Area Community Plan. The subject site is in the coastal high hazard, so please note that. The subject site has a future land use designation of residential 6. The applicant is requesting to rezone the property from agricultural single conventional 1 to commercial neighborhood with restrictions. To permit an indoor venue, banquet, or reception use facility. The property is located north of Hartford Street, and parcels north of that street is characterized more of agricultural, single-family residential, and residential support uses. To the south of that street is a trucking company operation. The area has normal business hours of operation, which are typically from 8 to 5. The applicant is proposing the following restrictions. The commercial neighborhood use will only be restricted to indoor and outdoor venue, banquet, reception center. Number 2, events on the property will occur on Friday after school hours, Saturday and Sunday. Number 3, the existing fence around the property will remain in place. And number 4, the events will take up place from 4 p.m. to midnight, other than setup and cleanup before and after events. Per policy 22.7, commercial locational criteria and goal 9 of the community design component, the subject site is not located at a designated community node in the community plan and does not demonstrate how it will avoid strict commercial pattern of the development. Planning Commission staff does not support the waiver and advises that the board not grant the waiver to commercial locational criteria. Additionally, Objective 16 and its accompanying policies 16.1, 16.2, and 16.3 require the protection of established neighborhoods and compatibility with the surrounding development pattern. The applicant has not addressed how their proposed uses helps protect established neighborhoods and has not addressed noise mitigation. Overall, the proposed rezoning not allow for development that is consistent with the goals, objectives, and policies of the future of Hillsborough County Comprehensive Plan for the unincorporated Hillsborough County, and that is not compatible with the existing plan development pattern found within the area or the standard utility zoning within the area. So based upon those considerations, Planning Commission staff finds the rezoning standard inconsistent with the future of Hillsborough County Comprehensive Plan for the unincorporated Hillsborough County. And I will stand if you have any questions.
I just have one, and that is to clarify what the qualifying intersection is that would you're measuring from for locational criteria. What is that intersection?
Right, so it is listed under policy 22.7, and there's certain criteria. So we take whatever the nearest intersection is, and it's usually listed in our maps. So we would look at whether or not there is a nearby collector or arterial road, and then we will use the intersection from there, and we will measure out depending on where the area it is. So in this case, I believe it's, let me double check staff report, and I will confirm with you. Yep, so Hartford Street, by the way, is a county collector, and 66th Street is a local road, as mentioned in the staff report. And according to policy 22.7, 1 second, Madam
problem.
Hearing Officer.
Thank you. That's fine.
Okay, so Madam Hearing Officer, when we measure the commercial locational criteria, we will look at the 2040 cost affordable capacity improvements map. So that is part of public record. And we will look to see whether or not the road is identified on that map, and then we will measure out specifically. And I apologize because the rezoning app is not working real well. So this is what we typically use, is the 2040 cost affordable transportation map.
Understood. So you testified that Hartford is indicated, it must be shown on the 2040 as a collector. Is that correct?
Yes. So
what is the intersection?
The intersection, it's with a local road, so it's too far away.
I understood. So is there an intersection that you're measuring that is the node? Maybe I'm not phrasing the question properly. What is the closest node? How far are they away from meeting it is my question, perhaps.
Correct. Let me try to pull it up, and I'll tell you exactly how far it is. And just bear with me. I apologize.
No problem. And you didn't know that I was going to ask this. So if you'd like, I can keep going and then come back to you and give you an opportunity to look it up.
Please. Yes, I would appreciate that. Thank you.
Perfect. No problem at all. All right. So we'll come back to the Planning Commission for that question in just a moment. But in the meantime, let me call for anyone that would like to speak in support. Anyone in support of this application? No one in the room, no one online. Anyone in opposition to this request? I see one hand, two hands. Okay. Do we have anybody online? All right. So you have 15 minutes total. So if you want to go ahead and come forward, we'll do 7.5 minutes per speaker. And if you could start by giving us your name and address, just pull that microphone down to you a little bit.
Thelma Fernandez, and I live at 6610 36th Avenue South. I'm just west of the school, and I'm 9.5 acres across the field from them. And the cops are called every weekend, if not every other weekend, because of the noise. The ordinance is 10 o'clock. It needs to be turned off at 10. The cross street that you're looking for is either Hartford goes out to Highway 41 and it dumps into 41, or it goes to the new subdivision that they just built, the Tower Dairy, and that's 70th Street. And if you go north on 70th, just before you get to Causeway Boulevard, there's an arena in there. They have weddings. We never hear them. They're every weekend. We've never had the police called there, but we call every weekend on these people. They have continually disregarded everybody in the neighborhood. Even if they do shut down to clean up, they rich the music back up. It's 2, 3, 4 o'clock in the morning before it closes down. As a matter of fact, hospice was in my house. March 30th, my mother-in-law passed away, my husband's mother. On the 27th, the hospice nurse called the police. It was that bad. Mom couldn't even sit in the bed. It rattles the cabinets, the china in the china cabinets. You can't sleep. You can't move. There's other people in the neighborhood, Chris and Julie Casada, my husband, my son, April Horn, Mike and Jennifer Transu, Chris and Tammy Transu, Jennifer Cathcart, her son, Jared, Mike and Ileana Costa, Mike Jr. Costa, and Leo Castellano. They're all against this, but they're older. These people are like my mother-in-law. She was 96 years old. None of them want this in the neighborhood. Back in the 70s, when this property was first started, it was just flat land. And we've been there since Chris and Judy were there in the 60s. It was a pole barn built. The facility that they're telling you, the little building, it is a pole barn that was closed in over the years. About 3 years ago, they had a big party. There was about 40 or 50 cars in there. They had to call tow trucks to get them in and out because it was the rainy season and they sunk down. It's just wet. The land is wet. It's going to be, I don't care what their land looks like. I don't care what they do as long as it doesn't interfere with what we do in our house and how I live. I've been there 42 years. Why should I change my way of living because they want to start a venue? I'm sorry. It wasn't zoned for that. It's never been zoned for that. It's always had code enforcement called on them. They're open cases. The case that was just recently closed by code enforcement was because they didn't have enough staff with COVID. They had a run of COVID and they didn't have anybody to go out to maintain the cases. So right now, code enforcement is aware of it. They've been out there. But they only do them on the weekends, Saturday night. They start at 2, 3 in the afternoon and it goes to 2, 3, 4 o'clock in the morning. How would you like to rest like that? It's ridiculous to live with them. And I'm sorry, I'm against it. And most of the neighborhood is. And across the street from me, directly in front of me, there's 9.5 acres. The gentleman's building 34 homes in there and it backs up. And the school, if you look at that picture that they gave you in the center of the school, there's a courtyard. The noise bounces in the courtyard and bounces out into our neighborhood. We can't rest. We can't do anything. And the traffic that it's bringing in, we don't even have a center line down. Most of our streets don't even have sidewalks. People ride horses. I mean, it's a rural neighborhood. The cars that come in, it's 40, 50 cars for each one or 100 for a venue for one night. Our neighborhood can't take that. Our streets can't take that. And if they go out at 8, 9, 10 o'clock at night, you've got kids. Something's going to happen. They're on go-karts. They're on four-wheelers. It's a rural neighborhood and someone's going to get hurt. Thank you.
Thank you for your testimony. If you could please sign in. Next, please. Good evening, sir.
Good evening. My name is W.L. Saxton Cook Jr. I have resided at 6210 36th Avenue South since August of 1963. That was a year after I was released from the Berlin crisis by President Kennedy. In the past, not lately, they've had parties that start at 2 o'clock in the afternoon. They never shut down at midnight unless a deputy sheriff managed to go by there, we would call. The noise was so loud. I have first generation double glazed windows. I have to sleep in the south bathroom because of my bad back. My wife can't hear too much from the front bedroom, but my south bedroom, I can hear through the double glass windows. And you can't sleep this drumming. They will play the drums, heavy on drums. And I expect some ethnic backlash because I look like a cracker, but I'm half Spanish. I didn't speak English till I was 6 years old. And I don't like that music. I grew up with Latin music. I didn't speak English till I was 6. My father spoke Spanish, Italian, and English. And it's just too much. I'm opposed to that zoning. If they want to build cut in 4 and build 4 houses, I'm fine with that. But I don't want that Ybor City moved 100, 200 yards south of my house. And that's what it's going to be, because I have seen beer trucks there on Saturday morning unloading. And I know they didn't have zoning for beer, and the building was originally a pole barn. They closed it in. Did they ever get a permit to build that building? I doubt seriously.
All right. Does that complete what you wanted to say?
That's it. I can't.
All right.
I'll get angry because it's been bullcrap for years.
All right. Thank you, sir. I really appreciate you coming down. If you could please sign in with the clerk's office. All right. Just one last look. Anybody else want to speak in opposition to this request? No one online? All right, then we'll close opposition testimony. Let me go back to the Planning Commission just to answer the one question.
Correct. Okay, so after looking it up, It's on the 2040 cost affordable map. The nearest qualifying intersection is Madison and 78th. That is over 10,000 linear feet away.
Away. Okay.
So it's way over what we would consider for CLC waivers.
Thank you. That's the clarification I was looking for. Thank you for that testimony. I appreciate it. All right. So we've closed opposition testimony. Let me go back to development services. Mr. Grady, any other comments?
Nothing further.
All right. Then we'll go back to the applicant who has 5 minutes for rebuttal.
How much time do we have?
5 minutes for rebuttal.
Let me, first of all, this is from the staff report. This is the future land use map from the staff report. And the planning commission and staff make a big point that the north part of Hartford, that the site's not compatible with. But as you can see, the tremendous amount of the area is light industrial, including the north part of Hartford. And between the site and the industrial is the property owner who supports, and then you have the school next door. Now, the school itself is also a very intensive use, hundreds of kids coming and going twice a day. So to say that the character of it is, as I took note, is residential rural, I think is drastically wrong, number one, that they are sandwiched between those two uses. So the pattern of the area is actually much different than that. We have addressed every staff condition by the restrictions for use, hours, days, and buffer, as well as the abutting neighbors. And I can tell you that what's on the record as of today about code enforcement is much different what the two folks said. My check of it today is that they were in compliant, and there were a couple earlier cases, and those, as I saw, were in compliance as well. I pulled up the Hillsborough County Sheriff's Office about calls at 6400 Hartford Street, and they show none. That's a quick check on my phone. I'm going to have to research that. But as far as I can see on those calls, there are none on the site. There's 2 on 36, the 1 on Madison, which are far to the north, for the south. You want to talk about what?
I just want to address
Give us your name first.
Oh, I'm sorry.
That's okay. Just give us your name.
Juana Soto. At midnight, my father personally is there for every event. So the turning up of the music, of cleaning until 4 or 5 in the morning is not so. As far as the building and the permit, that was done with permitting. Everything, we've owned the property since 1974. So I just wanted to clarify that.
So Ms. Soto is putting on the record that her father arrives at each event and closes at midnight. Is that correct? Have you had any?
We stay and we clean ourselves. So it's not a hired staff. No one's hired off the street, family themselves. We clean it. So there's no turning. My dad is a stickler about that. 11 o'clock, the music is off. And there's no beer trucks coming in and out. We don't sell liquor. We don't have trucks coming in and out of the property.
With great respect to the two residents who spoke, and I do have respect for anyone who comes down here, if I would just suggest that if there was that much of an issue of noise and impact, and these folks live on the other side of the school, which is very far away, very clearly we would have heard from other neighbors and other people, and we wouldn't have the abutting neighbors in support. Thank you.
All right. Thank you for that. With that, we'll close rezoning 22-0702 and go to the next case.
The next item is agenda item D1, rezoning PD 22-0439. The applicant's Bel Development LLC. The request is to rezone from CPV G6 to a planned development. Israel Monsanto will provide staff recommendation after presentation by the applicant.
All right. Good evening. Just push the button. Yeah, there you go.
Good evening, Jessica Iserman. I'm an attorney with Stearns Weaver Miller for 401 East Jackson Street. We do have a presentation, and while that's being brought up, I have some binders for the record. I actually have 2 binders, one for you, one for the clerk. If that would be acceptable to you, I'd like to enter them into the record.
Absolutely.
Thank you. And I am going to turn the presentation over to David Smith, our planner. Thank you.
Okay.
Good evening, David Smith, 401 East Jackson Street, Suite 2100 for the applicant. I'm the Director of Development and Zoning for Stearns Weaver Miller.
You sign in.
As indicated, this is a rezoning to PD 220439. You'll find a little bit of a theme tonight is that this is in a district that has special zoning regulations, the Citrus Park district. It has a community plan and its own comp plan designation. Next slide, please. Generally located, Gun Highway, Sheldon. Gun Highway runs east-west, then it turns north. Sheldon is on the western side. This property is in the front of a public anchored shopping center that has existed in the Citrus Park area for quite some time. Next slide. As indicated in the graphics, the zoning is CPV G6. Future land use is CPV subcategory G. As you can see on the graphic, the G designation surrounds this property. The G designation here is essentially all the commercial properties that are at the corner of Sheldon and Gun Highway. It is within the urban service area. Next slide, please. So looking at the site, here's an aerial. As you can see, there's a large public anchored shopping center, bank uses, pharmacy uses on the north side of the property. There's also a bank to the east. Sickles High School is immediately across and out of the frame on Sheldon Road. In the south side of Gun, there are additional commercial uses, also a charter school. There's one residential community that is just to the right, to the east on the south side of Gun Highway, and that is to the east of the public's entrance, main entrance. Next slide. So here's the site plan that has been submitted. As you can see, this is a very unique and oddly configured site. The western end of the site is approximately 66 feet in depth. The eastern side is approximately 88 feet in depth. Over time, there has been a taking that has occurred that narrowed the property, which results in that little indenture, so to speak, indent into the property line on Gun Highway. This is an fully automated car wash that's proposed for the site. The key elements is to consider here is that CN uses, which include automated car washes, are allowed already in the CPV designation. However, it's the design criteria for the plan that causes us to come before you tonight with the PD. Next slide. So when looking at this site, again, this is going from CPV G6 to PD for 6,445 square foot automatic car wash. The square footage of the car wash seems rather large, but it's a two-story element because you have the tube down below and the equipment is in the second level. Not all of the second level is utilized for equipment, but we went with the safer number at 6,445. Fully automatic self-service vacuums. The staff that are present on site are only there to maintain the site, make sure the equipment's operating, and basically if there's anybody that has a problem at the kiosk, they go in and take care of that problem. They provide no services, therefore it qualifies as an automatic car wash. Again, as I mentioned just previously, commercial neighborhood CN uses are allowed in the CPV G6, which would include an automatic car wash. Next slide. So looking at the goals and strategies in the Citrus Park Village Plan, drafted to achieve well-balanced variety of residential, recreation, commercial, and public uses while preserving the layout and character of the existing neighborhoods. It says was seen from the aerial previously up. This is really the commercial end of the corridor. This is where the intensity occurs. This is where it turns north. So predominantly, the character of the area here is there's an elementary school on the southern side next to the residential neighborhood. There's some scattered uses that pre-existed, some churches, and some minor commercial uses. This, to my knowledge, may be the first development of commercial development that's actually moved forward with.
Sorry, I'm sorry to interrupt it. Michael, the clock is not working on the time. Go ahead.
Okay.
We'll figure it out.
No problem. So this may be one of the first projects to come through as a PD that is going to be trying to be implemented within the Citrus Park Village, because it is very difficult to meet all the standards, design standards for the development, because it's trying to implement a T&D style development, pushing everything to the street, a lot of glazing and architectural elements with parking behind and those types of issues. So the FAR allowed is 0.25. The applicant's requesting the commercial use, and that will not alter the layout or the character of the area, because it is essentially an outlot to an already existing shopping center that was developed prior to the Citrus Park regulations being put into effect. Our proposed FAR is at the 0.25. Again, this was a conservative approach, counting the second story where the equipment is as FAR. Next slide. So looking at the consistency with the Citrus Park Village zoning requirements. So we comply with, in going to a PD, the basis is that you comply with the regulations to the greatest extent practical. And again, the code allows for you to apply in a PD for that purpose, and you must demonstrate how you've complied. So looking at the site, we have a build to line, maximum setback. So since it's in a regular lot, you have to put the building on an angle, and therefore we have 67.5% located to the build to line, but we've constructed a canopy that provides a front porch element that is built right to the build to line. So to the greatest degree practical, due to the angle of the that portion of the site, the narrowness of it, we were able to meet the intent of the build to lines with the proposed layout in the PD. Accessory uses, vacuum stations are located in the side yard because of the narrow lot. Typically, accessory uses would be in the rear of the property, or even parking would be in the rear. But the code already in Citrus Park already allows and recognizes this lot as narrow and provides for opportunities for those uses to be in side yards. So while the vacuum service area is really not a parking area and does not count towards our required parking, it is an accessory use, and it's located in a side yard consistent with those standards. Buffering and screening, we are meeting all the buffering and screening requirements of the Citrus Park regulations. Next slide, please. So non-residential mixed-use architectural and building requirements. And again, they keep on emphasizing to the greatest extent practical. Facades. Car wash is designed to mimic the architectural elements and resemble a commercial facade. In the Citrus Park standards, they have retail facades. They really don't have a service facade. But what we've done, and we'll show you in the elevations coming up, how we've incorporated in and added spandrel glass, additional glazing elements to the front to give it the effect of being a storefront on Gun Highway. Again, car wash is not a storefront, mimics the commercial facade, increases pedestrian access and connectivity in the area. We do have direct connection to the sidewalk along Gun Highway, also pedestrian connection directly through the property to the shopping center. Exterior cladding, we meet those requirements. It's architecturally finished on all sides. Building is one story with appropriate design elements, giving the impression of a two-story element. Again, the second story is equipment, and again we'll see that on the renderings. We've incorporated awnings into the architecture. We have structural canopies that meet the requirements of having structural canopies and balconies. The roof requirements, we have pitched roof elements to give it the more of a cracker feel, cracker architecture. Cornices have been incorporated. Parking and loading, again, mentioned the side yard. Build to lines mentioned again, and also other accessory structures. The dumpster is located in the rear of property and shielded from the right of way. Next slide, please. So this is the architecture, and I want to pause here for a second, because the one thing that's important here is the site plan itself. We do not have our own access directly to Gun Highway. We have an emergency egress point only that's gated. We have a PRS previously approved in the PD that abuts us, which is the public shopping center, to utilize their access point. So that limits the number of curb cuts on Gun Highway, which is a very busy intersection. And so all ingress and egress will be through the existing Publix shopping center drive. People will enter and exit the use through the rear of the property and then go back out onto either Gun Highway or Shelton by the existing access points. We also have a shared parking agreement is allowed under the PD to provide for 7 parking spaces that are really based upon the gross square footage, not necessarily, we don't have that many employees, but that is what the code requires. So looking at the architecture, the elements that I was displaying, and the only bad thing about the south elevation, we don't have parking in front because that's Gun Highway. So this particular element, we provided the glass elements at street level, and we have canopies for coverage and weather protection. People can sit out there while the car goes through the tube. So it provides a real connection to the street, even though it's not a retail use that you would walk to. It's strictly automobile driven. On the rear side, which faces the shopping center, we've also incorporated those elements of spandrel glass and windows and shutters. And as you can see by the kind of like double window door up on that is kind of an access port to the equipment room that's existing. And we've incorporated this mural treatment because it is Woody's. Woody's is kind of the old Woody station wagons used to be the surfer. So it ties in with the brand for this particular use. Next slide. These are the ends of the building. As you said, the entrance on the west elevation. Again, we've incorporated, there's glass and doors on that end. There's a canopy. And so it tries to keep that theme wrapping all the way around to give that sense of not just a big boxy building, but to meet the elements of design standards. And same on the east. Next slide. So looking at the zoning requirements, the only things that we cannot comply with or even come close to meeting is because the narrow and irregular shape of the lot. 2 Citrus Park Village LDC requirements are block pattern because the overall standard was to create a network and grid pattern throughout the community. This site is 0.59 acres, and at 0.59 acres, there's no grid to connect to. There's an existing shopping center, and so that is an impractical thing to meet. The maximum impervious surface, originally the site was a little bit larger. The impervious ratio at that time would not have been a problem, but we have proposed an impervious ratio, surface ratio of 69%. And that based upon the take, this is an auto-oriented use, that this is a reasonable request to support this use. Staff has found and agreed that these justifications for not meeting these requirements to be reasonable. Next slide. So staff has evaluated the requirements and explanations provided by the applicant in our application, which is also part of the package that we presented to you. Overall, the project conforms to the greatest degree practical with the provisions of the CPV LDC regulations. Surrounding parcels in the subject site are mostly developed prior to the adoption of the regulations. Therefore, if we're approved, we will provide a project that brings the area closer to the standards of the district. The site layout, building design, and development standards meet the intent of the district regulations. And the proposed project is bringing the area closer to overall community vision for Citrus Park Village. Next slide, please. Connectivity. Again, the connectivity on this property, we look at the ingress and egress to the property on the rear side of the shopping center. We're connected in protecting the access points and limiting them onto Gun Highway, off-site parking to accommodate the proposed use. We've accomplished access to the solid waste facility. So again, that's off the road. It's not trucks pulling into the site. And the 2 administrative variances were found to be approvable. And what these are currently the turn lanes pulling into the public shopping center are already do not meet standards. But our project puts de minimis impact, additional 4 trips, 3 trips or turns into those particular standards. And staff is, the county engineers found these approvable based upon the limitations right away under the minimus impacts. I'll be glad to answer any questions.
Just a couple. One was, I just looked while you were talking. So the renderings the elevations that you showed us, those are being adopted as a part of the approval and conditioned.
Yes, because looking at this PD in its totality, we had to demonstrate that we were committed to doing it. The elevations lock that in and show what we're going to build. And that based upon those elevations, I believe the staff has concluded that it meets the intent to the greatest degree practical.
All right. I think you answered my other question, so thank you. Does that conclude your presentation?
Yes, we'll just be available to answer questions or in rebuttal.
Perfect. Thank you so much. If you could please sign in with the clerk's office. All right, we'll go to Development Services.
Good evening, Israel Monsanto, Development Services. I will share my presentation. Second here, let me start sharing. Can you see my screen?
Yes.
Again, Israel Monsanto Development Services. This is Plan Development Rezoning 22-0439. The request tonight is to rezone a 0.592 acre site located on the north side of Gun Highway, east of Sheldon Road in the Citrus Park Village area. From Citrus Park Village G6 to a plan development to allow for the development of an automated car wash facility. The site is within the Citrus Park Village community plan area and is subject to the standards and regulations of the Land Development Code Part 310.00 Citrus Park Village. It's in the urban service area, and it's on the generally located on the western part of the Citrus Park Village area. The site is within a future land use classification of Citrus Park Village or CPV, and is a Citrus Park Village community plan. The subject is within sub-area G of the plan. The intent of this area is to recognize existing development within this sub-area. The sub-area will allow for commercial, office, and residential land uses or a mixture of these uses. It has an intensity of up to 0.25 FAR and a maximum density of 12 units per the gross acres. The area mostly consists of property zoned Citrus Park Village or CPV and also planned developments. Zoning districts in the vicinity are zoned for commercial, institutional, office, and residential. Commercial and office uses are located in the adjacent shopping center to the north. There are also schools, financial institutions, and other neighborhood commercial uses also located nearby. For the Land Development Code sub-areas G6 and 7, this area has a special requirements provision which allows parking areas to be located on the side and or rear of the buildings in those sub-districts, and this is due to the restricted depth of these sub-districts. The district, again, is limited to commercial neighborhood uses. The project would consist of an automated car wash, as stated by the applicant, and this use is permitted in commercial neighborhood use districts. The applicant proposes to limit the site to an FAR of 0.25 and generally conform with the maximum building setbacks per the Citrus Park Village regulations. The building is being placed along the southern PD boundary with parking and vacuum to the side of the structures. Additionally, the applicant has submitted elevations for the car wash structure as shown in the staff report on the screen, and will be added to the certified site plan. Waivers are being requested to certain provisions of the Citrus Park Village standards, specifically building design, flow pattern, and impervious surface, maximum impervious surface. Staff has evaluated the explanations provided by the applicant and has found them reasonable. The site design in relationship with the irregular shape of the lot, in addition to the proposed building design, result in an overall project that conforms to the greatest degree practicable with the provision of the CPV Land Development Code regulations. The majority of the front facade of the proposed building is being placed within the prescribed 10-foot maximum front setback from Gun Highway. The vacuum spaces placed to the side of the structure function very similar to parking for the users of the car wash facility. Subdistrict G6, again, allows for the placement of these parking areas to the side. The applicant has also committed to a building design that nearly meets all design requirements found in Land Development Code Section 31014. Furthermore, the design is consistent with architectural style, which is the Florida Cracker, in which the shopping center behind it in the PD to the north was approved. Notably, parcels surrounding the subject site were mostly developed prior to the Citrus Park Village adoption. Therefore, the subject site, if approved, will provide a project that brings the area closer to the standards of the district. Direct pedestrian access to the building is being provided, and the design of the building will be of a design that mimics the front facade oriented to the public right-of-way of a storefront. Existing development pattern surrounding the subject site prevents the establishment of a new block. Additionally, the proposed project seeks development of an existing single parcel that has been vacant since the adoption of the Citrus Park Village regulation. Transportation staff also reviewed the waiver to the block pattern and finds that the request is acceptable, as explained in their staff report. The proposed increase in impervious surface is also reasonable since the original limits of the property have been reduced due to road expansions in the area on the Gone Highway. The original parcel site was approximately 0.77 or 75 acres, but the site today is just below 0.60 acres. At the maximum allowed 60% impervious area of the sub-district G6 for 0.75 acres, for example, up to 9,863 square feet of impervious surface will have been permitted. But the proposed project provides less than 18,000 square feet of impervious surface. Our department received letters opposing to this rezoning request. Residents expressed concerns with traffic congestions, additional traffic impact with the proposed use, the existing of schools in the proximity of the intersection, tree preservation, impacts to wetlands, and other similar businesses being proposed in close proximity. The Citrus Park Village Community Plan recognizes the restricted size and configuration of sub-area G and provided for flexible development. The proposed design of the site takes advantage of this provision while meeting most of the Citrus Park Village development standards. Additionally, while the use itself is not retail use, Subdistrict G allows CN uses, where an automated car wash is a permitted use. The proposed site and building design provides a look of a retail building with architectural elements similar to other approved commercial uses in the area. Transportation staff also received calls and letters from concerned citizens in regards to the traffic and high number of accidents in the vicinity, and they explained their staff report what they found about these arguments proposed by the provided by the residents in the area. The plan development will be conditioned requiring the site design and building elements for the submitted site plan and renderings to ensure conformance with the Citrus Park Village development standards as proposed. The staff recognizes that the applicant has made efforts to comply with the provisions of the CPV development standards found in the code. The site layout, building design, and development standards meet the intent of the district's regulations, and Planning Commission also found the request meets the intent of the Citrus Park Village Community Plan, which is to ensure the development of a well-balanced, vital, pedestrian-oriented traditional village that can support a variety of residential, commercial, office, and civic uses. The CPV provides for projects to be conditioned to conform to the greatest degree practicable with the provisions of the CPV part, subject to approval by the Board of County Commissioners, and staff finds that this project would also be consistent with these provisions. Surrounding sites in the vicinity are not developed in accordance with the Citrus Park Village development standards. However, site development standards and building design proposed for the subject parcel would meet most of the Citrus Park Village standards. The proposed use and scale are compatible with the character of the area, conforming to a commercial parcel of the adjacent shopping center, and therefore fits within the nearby commercial corridor. The proposed project is bringing the area closer to the Citrus Park Village community vision, harmony with a mixed-use district with an urban character and variety of uses. Our department received no objection from other reviewing agencies, including the EPC or transportation. And based on these factors, staff recommends approval with conditions. And we have provided an updated staff report indicating the Board of County Commissioners' correct meeting date. And now I will also notice that the table in the first page needs to be corrected for the acreage and FAR, and that's for the table for the existing zoning and proposed zoning. Both current and proposed zoning is to state 0.592 acres, and also both FARs are 0.25. And that would have mathematical maximums of 6,445 square feet. And the reason why this is noted is because in our GIS maps, the subject parcel has about 0.77 acres, but the actual size is less because of the Gun Highway Road expansion. So we will provide an updated staff report in optics for those with those corrections.
All right, Mr. Monsanto, just one quick question before you leave. So the staff report, and I have the revised staff report that was submitted into the record this evening. The staff report says that the two standards cannot be practically met, and that's the block pattern and the maximum impervious surface. Is it accurate then to say not only that, those two that they can't meet, but they also, and I think Mr. Smith said close to complying, was the build two lines. They don't 100% comply with that, but it's close. Is that correct?
That is correct. If you look at the site plan, there are these areas here that are not at the maximum. These facades are at the maximum, but these, I guess, courtyards are not. However, the courtyards are covered by this building, which makes them meet the standard completely.
So it's those three standards of the Citrus Park Village requirements that they don't meet?
For the most part, yes.
For the most part. Okay. All right. Thank you so much. That was my only question. Planning Commission, please.
Carla Llano, Senior Planner with Planning Commission staff. The subject property is located within the Citrus Park Village Community Plan and is within the urban service area. The property has a future land use designation of Citrus Park Village Sub-Area G. The intent of Sub-Area G is to recognize existing development within this sub-area. Sub-area will allow for commercial, office, residential land uses, or a mixture of these uses. The applicant is requesting the rezoning from Citrus Park Village G6 to planned development to allow for an automatic car wash. The Citrus Park Village Community Plan is implemented through the adoption of specific district plan and regulations in the Hillsborough County Land Development Code and Zoning Atlas. Detailed standards for the land uses, densities or intensities, and design requirements are defined within the Citrus Park Village Zoning District Plan. The proposed rezoning will meet all but two of those requirements as previously stated by Development Services staff and the applicant. Again, one of them is the maximum impervious surface and the other one is the block pattern. The property has physical constraints which would prevent them from meeting that criteria. Overall, the request is found consistent with Objective 16 and its accompanying policies in the future land use element, Goal 12 and Objective 12.1 of the community design component, as well as it's found consistent with the Citrus Park Village Community Plan. Overall, the proposed rezoning would allow for a development that is consistent with the goals, objectives, policies of the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County that is compatible with the existing and planned development pattern within that area. Based upon these considerations, Planning Commission staff finds that the proposed rezoning plan development consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County with the subject to the conditions that are provided by Development Services Department. And I will stand if you have any questions.
No questions at this time, but thank you. We'll now ask for anyone that would like to speak in support. Anyone in the room that would like to speak in favor or online? No one? How about in opposition? Anyone opposed to this request? I see no one in the room. Anybody online? Okay. All right. So last call. Nobody else in opposition. Mr. Grady, anything else?
Nothing further.
All right. The applicant has, Mr. Smith, you have 5 minutes for rebuttal if you'd like.
Good evening, Jessica Eisterman for the record. I just want to clarify real quick. There are two standards we absolutely cannot meet. That's the impervious standard and the block standard. There is another standard, which is the build to line. It actually appears twice in the code. And one of them is under the building requirements like architectural standards. We are complying to the greatest extent practicable with that standard.
Right. That's what I was clarifying with Mr. Monsanto. So completely can't meet the block and the impervious.
Correct.
And almost meet the build to.
Exactly.
Perfect. I understand.
Thank you.
All right. Thank you. Appreciate it. Then with that, we'll close rezoning 22-0439 and go to the next case.
The next item is agenda item D2, rezoning PD 22-0441. The applicant is AMH Development LLC. The request is from ASC1 to Plan Development. Michelle Heinrich will provide staff recommendation at the presentation by the applicant.
All right, Mr. Malloy, if I could just stop you before we go, we had some folks walk in. I just want to make sure everyone's been sworn in for this application or the last item on the agenda. If you plan to speak to this item, if you have not, is there anybody who's plans to speak and has not been sworn in? Anyone at all? Okay, good. All right, go ahead, Mr. Malloy. Thank you for that.
Good evening, William Malloy, 325 South Boulevard, Tampa, Florida. I am going to jump right into this and assume that the particulars of this project are all confirmed as a matter of record in the staff report. In short, we've got 7 acres of dirt in the urban service area with a future land use of R4. We're asking for only 22 single-family detached units there. The Planning Commission and Development Services are not supporting this request. For the stated reason that our proposed lot size of 50 by 110 are incompatible with the surrounding area and development patterns. In a microcosm, I might agree with that statement, but I really truly believe that the analysis staff has used here is just a bit skewed, and I'll show you why. This is from the staff report. This is our, there, okay, there we go. So this is our project, the proposed 22 units, and you'll see that staff has really assessed everything only south of what we're proposing. Just a quarter mile north is State Road 580 or Hillsborough Avenue. So again, as I said, we're proposing 50-foot lots with as well within our rights under the R4 future land use designation. There's no minimum lot size in a PD. There's no minimum lot size required in R4. So again, in this graphic, I think it's a bit disingenuous to only point to the south, not to the north. I also think it's a bit, it flavors this to point out that of these 14 references, 9 of them, I believe, are Euclidean zonings, which there's no flexibility in the lot size. It's all based on gross acreage. The lots are what they are. They've not been redeveloped to a PD. They're still in a Euclidean zone. As to the first point I made, again, I'm going to go back to paper. This is a broader scale. And again, this is from a previous staff report. Look at the surrounding area. This is our project. This is a commercial equestrian center. This, as best we can tell, is one homestead and a smaller house that is used as a vacation rental. Directly across the street from us to the south, and you can see it better on the previous graphic, is a subdivision approved for lots of minimum 9,000 square feet.
Mr. Malloy, we're just having, you got to pick one or the other, right?
Yeah, I gotcha. Very good.
Thank you.
So which leads me to this graphic. This is a quarter mile radius. This is the middle of our site. Hillsborough Avenue again. This is an ocean of retail and asphalt. Every piece of property that comes off of Hillsborough here has a future land use of OC20, 20 units to the acre. Again, our site, this apartment complex here, 581 units. Okay, we're asking for 22 here.
Let me ask you, if I can interrupt your presentation, let me just ask you a question while you have that graphic up. So your site, that's 580 that you're pointing to with the commercial development to the north of you, correct?
Yes.
And so your site is south of that, and it appears that a wetland or some sort of natural feature divides you from that commercial area. Would that be accurate?
I believe that's top of the green.
Okay.
Is what it's called.
And your site then is oriented to the south on that road that escapes
Right. Our primary access would be on State Street.
State Street. Yes. Okay. Understood.
So
Let's proceed.
thank you very much. So again, I consider this, in my very professional estimation, a classic example of how development is intended to de-escalate. You've got 580, you've got OC 20, you've got one parcel essentially that separates our project from that intensity. And we're asking for only about 78% of the allowed intensity for our development here. Okay. If this wasn't the coastal high hazard area, I would have to defend that position about why we're under zoning it at this point. We did have a community meeting. It did not go very well. We're fairly far apart with the residents on this one. I think they were very disinclined to support the larger development across the street from us. So us being a smaller development, we didn't get a lot of traction with that. There was also significant concern about drainage, and I have our project engineer who is qualified to speak to that. I am not qualified to speak to drainage issues. I'm not an engineer. So again, that's our story. I'm a little bit frustrated again with the analysis that was given to this project. I believe it is a very appropriate underdeveloped project that we're asking for here. I would point out finally too, and this is really just kind of a nit, but while the Planning Commission was very firm that we're not compatible with the surrounding area, we do in fact meet the intent, and this is specified twice, of both the Northwest Hillsborough and the Town and Country community plans, which in my usual experience is more specific and therefore more controlling than the comprehensive plan by itself. Again, I don't think that's compelling, but it's helpful. With that, I'm going to bring up Mr. Amidon to explain what we have to do with this piece to make it developable and allay any concerns, hopefully, about drainage, et cetera.
All right. Thank you so much. If you could please sign in.
Nicholas Finch.
Good evening.
Good evening. Todd Amidon, Landmark Engineering, 8515 Palm River Road in Tampa. I am the engineer of record for this project. I want to just touch on a couple items that you'll probably hear more about in a little bit. Stormwater and placement of fill. The historic stormwater patterns in this neighborhood, according to the neighbors, it floods and it's believable. It's a lower lying area. I believe that never had a design. It never had a municipal design. There's no existing stormwater facilities in place. You can point to the project across the street, immediately across the street from this project. It does have a municipal system, and I'll comment a little bit on the roads and the ponds in a minute. And it does not flood. For the stormwater design, the governing agencies, as you may know, Hillsborough County Stormwater, Environmental Protection Commission, Southwest Florida Water Management District, all have regulations governing stormwater design. So the design ensures that you meet all criteria of all these agencies for water quality treatment, water quantity attenuation, and floodplain encroachment compensation if any is required. And all these things guarantee that you have no negative impact on surrounding properties. You can't block water onto private property, and you can't discharge water onto private property that wasn't already discharging there. Moving on to Project Fill, as you know, the fill placed on projects is required by county codes. The roadway has to be at or above the 25-year design high water. The lots have to be at or above the 100-year design high water. So you design this municipal system, and there's certain regulations that require, if developed, that you place fill in them. So in summary, the fill and the stormwater design for the project cannot by law have an adverse impact on the surrounding properties. And the last item was there is a jurisdictional wetland line adjacent to the aforementioned creek. It's been delineated, and there are no proposed impacts, environmental impacts to that. Stand for any questions?
Not at this time, but thank you.
Thank you.
If you could please sign in.
William Malloy again. Ms. Finch, I'm going to introduce Mr. Alex Alejandro here, who is our client, the developer. He's going to detail a little bit the peculiarity of this development and one of the issues that the residents really took issue with in our meeting with.
Okay.
So.
Good evening.
Good evening, Ms. Finch. Thank you for listening to our presentation. My name is Alex Azan with American Homes for Rent, address 3923 Coconut Palm Drive in Tampa, Florida. I'd like to tell you a little bit about us, American Homes for Rent. We are what's called a BFR, a Build for Rent organization, essentially a home builder. We'll go in, we'll develop the property, place the infrastructure, build the homes, and actually rent the homes out to families minimum 1 year period. We formed in 2012. We're in about 22 states, have approximately 57,000 rental properties. We're at last count the 45th largest home builder in the nation. Again, we are a REIT, R-E-I-T, a real estate investment trust. We're a publicly traded company, and we had some concerns expressed at our community meeting that we'd like to address. For example, we are always concerned about the safety, welfare of our neighborhood, as well as surrounding communities. We do perform criminal background checks, everything within the limits of the law as allowed per local regulations. When I say that we're the owner, developer, home builder, we provide fenced-in yards, completely maintenance-free lifestyle, so that people can live in a house of their choosing. They don't have to worry about the lawn maintenance, any house maintenance. They call us anytime they have a concern or need something addressed. It's a lifestyle that certain people gravitate towards. It's our business model. We've been very successful. We've had good experiences throughout the country. And if there are any questions, we would welcome answering them.
No questions at this time, but thank you for your testimony.
Thank you.
You could please sign in with the clerk's office.
William Lloyd, and that concludes our initial presentation. I do have draft conditions to hand to staff and a very gentle reminder about what constitutes competent testimony.
Thank you so much. I appreciate it. All right, we'll go to Development Services, please.
Hi, good evening, Ms. Finch. Are you able to hear me?
I can.
Okay, great. I'm going to go ahead and share my screen. And hopefully you're able to see the presentation okay?
I can, yes.
Okay, great. As you heard, this is a rezoning request. This is PD 22-0441. And this request is to rezone from property zoned ASC 1 to PD. And the purpose of that is to allow for 22 single-family homes. The minimum lot sizes proposed are 5,500 square feet and 50 feet in width. This is in the Res 4 future land use category, and the project size is about 7 acres. The property is located in the Town and Country Community Plan area, located on the north side of State Street, east of Racetrack Road. And a PD rezoning is required in this instance due to the proposed lot size and the property's presence in the coastal high hazard area. The future land use category, as stated, is Res 4, and typical uses in this category include residential and non-residential projects. When a residential project is proposed, the maximum density is 4 units per acre. And because this site is located in the coastal high hazard area, the minimum density policy is not applicable. The information we received from Planning Commission staff found the request to be inconsistent with the comprehensive plan on the basis that it is incompatible with the surrounding development pattern and is located in the coastal high hazard area, and the report states the applicant has not demonstrated the impacts of the proposed development on the existing infrastructure. What you have here before you is the proposed layout. As you can see, it's a cul-de-sac roadway with lots on either side. As I stated, the minimum lot sizes of slightly over 5,000 square feet. The stormwater pond would be located along the east, a 20-foot buffer with type B screening along the west. And as you saw previously noted, wetlands and a waterway are to the north of the property, and there is one access point proposed, and that is on State Street. This is the analysis that Mr. Malloy brought up earlier that is found in our staff report when we looked to see what the surrounding lot sizes are in the area. As you see from this, we centered our analysis on the immediately adjacent properties and those that are residential. The properties to the north, as you can see on that zoning map, are commercial and therefore would not be comparable to this project because it is a different land use, and also in the OC20 future land use category, which is a different plan intent for that roadway. What we found was that in keeping with a 4 unit per acre minimum lot size, that would be about 10,000 square feet. And the PD to the west, which is currently, as Mr. Malloy stated, a equestrian type of facility, that is the interim use. It has been approved for a PD rezoning for minimum lot sizes of slightly over 14,000 square feet. To the immediate east is RSC3 that also has a minimum lot size of 14,520 square feet. And we did note in our report there is one non-conforming lot in that zoning district, but that lot is over 10,000 square feet in size. To the immediate south is RSC4 zoning. And as I stated earlier, they are complying with the standard zoning district requirements of 10,000 square foot lots. And you'll see in general around this area, we found lot sizes as small, which was mentioned, 9,000 square feet, and some as large as 5 acres. And yes, we did note on here, there are Euclidean zonings that are present in the area. However, I would note that all of the land that you see here highlighted is in the Res 4 future land use category. And because this was found inconsistent with the comprehensive plan and compatibility issues were identified by Development Services and Planning Commission staff, we do not recommend support of the proposal. And just to touch on a few things that were mentioned by Mr. Malloy, I would state again the lack of analysis on the property to the north. Again, that is State Road 580, a major commercial corridor. It is also within the OC20 future land use property or category. And the multifamily project that was also within, I believe, that 5-mile radius, which was northeast of the subject site, that is a rezoning from 1996. And it is also in the OC20 future land use category oriented towards State Road 580. And with that, I'm done with my remarks and I'm happy to answer any questions you have.
No, my only question was to talk to you more about that analysis and regarding Mr. Malloy's comments, but you've adequately addressed that for my question. So thank you for that. I appreciate it.
Thank you.
We'll go to the Planning Commission, please.
Carla Yano, Senior Planner of Planning Commission staff. The subject property is located on approximately 7 acres within the urban service area. It falls within the limits of the Northwest Hillsborough and the Town and Country community plans. The site is in the coastal high hazard area, as previously mentioned by Michelle. The subject property has a future land use designation of residential 4. Typical uses of residential 4 include residential, urban scale neighborhood, commercial, office uses, multi-purpose projects, and mixed-use development. The applicant requests to rezone the property from agricultural single-family conventional 1 and to planned development to allow up to 22 single-family residential homes on minimum size lots of 5,500 square feet and a lot width of 50 feet. The immediate surrounding properties include agricultural, single-family residential lots. Further north along West Hillsborough Avenue are vacant light commercial, light industrial, and a mobile home lot, and public institutional land uses. Residential properties immediately to the west, east, and south of the site have larger lots ranging from approximately 4.75 acres to 0.2 acres in size, or approximately 8,700 square feet. There are few smaller lots further to the south of the site that are below 0.20. Further southeast of the site, approximately about a third of a mile, it's about 1,900 linear feet, are some residential lots that are approximately 0.05 acres. However, the majority of the immediate surrounding area is a minimum lot size of greater than 0.20 acres or 8,700 square feet in size. Also to note, there's significant amount of wetlands in the other areas that have the smaller lots. So the most likely scenario would have happened if they would have clustered probably development to be able to gain that reduced lot size. But overall, it should be consistent with the future land use category and with the surrounding development. The proposed PD is inconsistent with the intent of policy 1.4, objective 16, policies 16.1, and the applicable policies are subsequent policies after. Per policy 6.2, the property owner shall provide adequate data to assess the impacts of proposed development upon existing infrastructure within the coastal high hazard area, as well as the level of service standards established for shelter capacity and clearance times. The property owner has not included a narrative that provides any information on how policy 6.2 is being met. Overall, the proposed rezoning would not allow for the development that is consistent it's found inconsistent with the goals, objectives, and policies of the future land use element of unincorporated Hillsborough County Comprehensive Plan. The rezoning request is incompatible with the existing residential development pattern in the area. So based upon those considerations, Planning Commission staff finds that the proposed plan development is inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Now, I can stand if you have any questions, Madam Hearing Officer.
None at this time, but thank you so much. All right, now we'll call for anyone that would like to speak in support, anyone in favor of this application. I don't see anyone in the room, no one online. How many people would like to speak in opposition to this request? You could raise your hand. How many people? Now, you may have missed this at the beginning. Let me count. We have 15 minutes total for your complete opposition testimony. So if you could raise your hand, if you plan to speak, if you want to have one person testify for you, you could do that. Absolutely. Yeah. So if you want to split the 15 minutes between the two people, and then if the other people just want to raise their hands. Okay. Go first, Jared. Perfect. How many minutes for the first speaker did you want to do? Ma'am, how many minutes? 4 minutes and 11. Okay, so if we can do 4 minutes. Thank you for working that out. That makes our lives much easier.
Yes, ma'am.
If you could start by giving us your name and address, please.
I'm Jared Vernon. I live at 12910 Parsons Road, Tampa, Florida, 33635.
Thank you. Go ahead.
So I just wanted to start with a couple of pictures of the neighborhood just to kind of give a little breakdown of what we have. So as you see, we live in a coastal community, a lot of fun kayaking on Upper Tampa Bay. This is the road leading into the neighborhood here that shows that this is the only entrance that would be to the neighborhood, our whole neighborhood back there. So we'd have 22 more houses, a ton of more cars on a not even a, it's not a legal 2-lane road. This is one of the horse farms that was a beautiful part of our neighborhood. We lost the horse farm next door where the PD is looking to go. Bald eagles, animals all over the place. We've got bobcats. You can go to the next one. Peacocks roam the neighborhood. There's flocks of them everywhere. We have horsepower for kids farm in the back. So there's all kinds of wild animals. It's a beautiful place, as you can see here. Horse and buggies, people riding horses in the streets. And again, the end of our neighborhood, we're right on Upper Tampa Bay. So there's a ton of flooding in the back. If we get high tide and a lot of rain, the roads flood. It's just way of life. These are the houses, the new ones that have been built in the back. So they're stilted, large garages. This is the kind of community that we live in, large houses, big lots. Next. Again, another big house. The whole bottom floor is a garage, stilted, 22 feet above sea level. Next one. Kind of the same thing here again. Stilted houses on Upper Tampa Bay. So that's all the pictures. I'll just go to the next. We want people in our neighborhood, builders. We understand it's going to be zoned R4. We can't do anything about it. But America Home for Rent, if you just Google on the internet, bad reviews for days. 2 out of 5 star rating on Yelp, You can go down to the BBB, a 1.25 rating out of 5, 825 complaints in the last 3 years. Again, you can go to, sorry, I'm trying to make it quick here.
I appreciate it. Thank you.
On Indeed, horrible place to work. It's just ads for days of bad reviews. So I'll just close with this. You know, we lost a beautiful horse farm. A planned development does not fit the character of our neighborhood at all. The increase of 22 homes would increase traffic, could possibly increase crime. It could increase already the flooding problem. There's a beautiful horse farm to the left, a beautiful stilted house to the right. We would just like you to consider the character of our old Florida living that we have back there. That's it.
Thank you for that.
Thank you, ma'am.
Appreciate it. If you could please sign in. Good evening.
Good evening. Madam Hearing Master. Can I lower this?
Please.
Okay. My name is Susan Martin, and I live at 7901 Racetrack Road. And I just want to go off, I worked really hard on my speech, but I want to go off script for 1 minute and address something that Mr. Malloy said about the development on Hillsborough Avenue and a transition that is not part of our neighborhood. It's totally different. And I feel, and I think my fellow neighbors would feel, should not at all be considered part of what's appropriate for our neighborhood. As noted by both the Hillsborough County Planning Commission and the Hillsborough County Development Services, the subject plan development is inconsistent and incompatible with development in our neighborhood. In fact, both departments have concluded that it should not be supported. My neighbors and I also overwhelmingly concluded that it should not be supported. In fact, I think we lost some people, but if everybody in the room who is not supporting and is in opposition to this plan development would raise their hand. Basically, almost the entire remaining room except for the developer and his support team. We feel so strongly about the development's incompatibility that we have spent hours, days, weeks, and months in voicing our many objections. This is reflected in the PGM store support/objection file, which is by far the largest file pertaining to the rezoning request. Not surprisingly, it does not, as far as we know, and I checked again this morning, contain even one single shred of support. We sincerely hope you have or will take the time to review the objection file, which contains our numerous legitimate concerns surrounding the project. We love our unique, beautiful, and ecologically fragile neighborhood and will do all that we can to protect it. Our first concern is the proposed lot size of about 1/8 of an acre. The lot size combined with the proposed setback reflects an R9 land use and not an R4 land use. Both the subject site as well as the surrounding areas within the R4 future land use category and not the R9 category. A subdivision of houses built 10 feet apart on tiny lots is not compatible with surrounding development nor with the character of our rural flavor neighborhood. Both the Planning Commission as well as the Development Services Department have covered this inconsistency adequately, and therefore I won't belabor it any further. Our second concern is absolutely flooding. Our entire neighborhood lies in the AE flood zone in the coastal high hazard area. The land is flat and low with natural elevation averaging 5.5 feet or less above sea level. The neighborhood is subject to severe and repetitive flooding. Flooding is especially severe and dangerous during storm and high tide events, which are happening more and more frequently. During high tide events, or what those in the neighborhood, we call it the bay coming up. And this is where the tide rises higher than the drainage system, and salt water actually flows into the neighborhood. At the same time, the fresh water from heavy rainfall cannot flow out. And we have a map, a bigger map of the site, and it shows how close to a Upper Tampa Bay, the site is, and has already been mentioned previously. In the back of the site is Copper Creek, which flows through the wetlands and directly into the bay. The use of fill dirt to elevate the two existing subdivisions has worsened the problem dramatically. The fill blocks natural drainage patterns. Additionally, the rainwater runs off the fill mounds and adds to flooding, submerging roads and surrounding properties. This is not theory, this is fact that has negatively impacted many of us in the neighborhood. And here we have, this is, I think, of particular note, flooded roads. Now, the site is on State Street, close to Bay. And Bay goes north and south, State east and west. And if you would look at these, this is where, so this would be the access, the only ingress and egress. You can see the roads are completely underwater and impassable. And the other one, Selma and Bay, that's just slightly south. More flooding pictures. The one on my right is the property beside the subject site. You can see the whole field there is flooded, and then other flooding pictures. Since the last subdivision, Eagle Point, was developed, FEMA has redrawn the flood maps due to increased flooding across the country. In the AE's flood zone, the minimum elevation for the lowest living floor has been increased from 9 feet above sea level to 11 feet above sea level. Even 9-foot elevation required massive amounts of fill dirt trucked into the neighborhood. The new 11-foot minimum elevation will require incredible amounts of fill dirt for the slab on grade construction method that the applicant intends to employ for the construction of this project. This construction method will only add to the flooding misery already occurring in the neighborhood. At the, Mr. Malloy referenced the neighborhood meeting held by the developer. And at that meeting, claims were made that flooding would not be a problem created by their plan to bring in massive amounts of fill for slab on grade construction. They said flooding would not be a problem since professional engineers would be required to design an effective drainage system in order to get the project approved. We differ with this claim, and we offer the following photos which depict the results of engineering failures related to the two existing subdivisions. The first, can you put the other one back? Oh, okay, yeah. The first one, the point of these two pictures, these were taken toward the end of the dry season. The first one is the Eagle Point, which is the one straight across from the subject project, proposed project. And even though you would think that the retention pond would be low, as you can see, it's at capacity. It's around the drain there. It's completely filled. Also, if you look at and the second one is the Eagle Point retention pond as well.
About 3.5 minutes left.
Oh, wow. Okay. This is really, okay. The Martin, this is my property. I'm Susan Martin, the Martin property. That's flooding after fill was brought in to Marsh Point. And I would state by the same engineer, Landmark Engineering, was the engineer for Marsh Point. You can see on the left the elevation difference. That's the lot right behind my property, and you can see how low I am. The other picture shows that is the property to the east. Susan Jackson, who's right over here, and her husband Rhett own that property. You can see where the rain's running down and has flooded their property as well. This is my property. Those are my miniature pet donkeys. You can see their entire area is flooded. That one's also my property, entire area flooded. After 2 years of having a mosquito-infested swamp, I finally got SwiftMud involved, and they put pressure on the developer. And what you're seeing there is I finally got the developer of Marsh Point to get REPA in and put a huge drainage system on my my side of the land in order to alleviate the problem. And that's some of the things they brought in. And on the other photo, you can see the difference in height between my property and the house up in the fill dirt. Traffic. Our next concern is speeding and ever-increasing amounts of traffic in our neighborhood. The area is secluded and rarely patrolled. Drivers prone to speeding know this, and speeding is regular and blatant. We have no traffic calming devices such as speed bumps. The use of the road, they need a variance. It's a substandard rural narrow road, and their traffic consultant even states that it's the narrowest, the numerous equestrian properties with horses regularly riding in the road. She showed that as a positive, that the horses would, and the narrowness would slow down the traffic. We strongly disagree. We use the same 90% of the neighborhood, the only ingress and egress is State Street. We applied the same formula to all the existing houses plus the 22 added houses, and that's 152 houses, which means that road, after the 22 houses developed, would have 1,824 average annual daily trips. They're dog walkers, scooters, bicyclists, baby strollers, everybody on this narrow substandard road. Also, the intersection of State Street and Racetrack is the bus stop, designated bus stop for elementary, middle, and high school for both Pinellas and Hillsborough County. So that adds to our concern. There are the bus schedules.
You've got about 10 seconds left. I'll ask you to wrap it up, please.
Okay, I'll wrap it up. Our last concern is the effect on the environment. We have a letter from the Sierra Club. They don't support it. It's in the PGM store for your review. In conclusion, we feel the subject site, for many reasons, is not appropriate for the plan development, should be denied. Thank you for your time.
Thank you for that. And you can submit whatever you'd like into the record.
Thank you.
All right. So with that, please, we'll close the opposition testimony and we'll go back to Mr. Grady, if you have any additional comments.
Nothing further.
All right. Then Mr. Malloy, it's your time for rebuttal.
William Malloy again, 325 South Boulevard. There we go. This is not my favorite thing to do, but I have to object to most of the testimony that we just heard. That was lay testimony. It was not professional testimony. It was not.
Let him talk, please.
We could go to the Elmo. This is case law. This is substantiated. This is real.
Sir, it's not appropriate. It's not appropriate from the audience, please. Please let him continue and finish the process. Thank you. Go ahead.
This notwithstanding, I also have to object to the photographs we were shown. There's no context for those, no timing, no indication of where they were geographically. Those could have been photos from anything as far as I'm concerned. I know that is not going to play well. Just a few other points that occurred to me as I was sitting there. I've heard several times that the development pattern, the development that what we're proposing is not consistent with the development pattern of the area. I would challenge anyone in the room to tell me what that development pattern is. I mean, we have Hillsborough Avenue. We do have some larger lots. We have CG. We have commercial intensive uses. We have a professional equestrian farm. This area is a mixed bag of uses. We don't have like uses immediately adjacent to us, but like does not mean compatible. Compatible does not mean the same. I really want to reinforce that. And then finally, the comments about the coastal high hazard area and our infrastructure in the event of a natural disaster. It was our understanding that was largely satisfied by the traffic study that was included with this application, which would obviously include the amount of traffic in a worst case scenario that would evacuate onto 580. If there's more information that we need to provide to the Planning Commission in that regard, we're more than happy to do it, but we thought that was the burden we needed to meet there. So with that, I'm happy to answer any questions.
I don't have any further questions, but thank you for your testimony. So with that, we'll close rezoning 22-0441 and go to the last case.
The last item is agenda item D3, major mod application 22-0452. The applicant's Woodfield Acquisitions LLC. The request is for a major modification to existing plan development. Tim Lampkin will provide staff recommendation after presentation by the applicant.
All right. Is the applicant here? If we could clear the room quietly so we can finish the agenda, I'd really appreciate it. Go ahead, Ms.
Good evening, Cammie Corbett with the law firm of Hill Ward Henderson, 101 East Kennedy Boulevard, Suite 2700. And I have a very brief PowerPoint. We'll be quick tonight. It's been a long night. This is the surrounding, this is the surrounding area. This is Falkenberg Road, this Palm River Road, I-75. It's where the Bass Pro Shops are located, Dave and Buster's, a lot of multifamily in the area, the Caravana Tower, the Home 2 Suites, and then to the south, you've got the flying indoor skydiving and Top Golf. This is one of the last remaining developable parcels in the Estuary PD. And we are, next slide, proposing two development options. One is retain the existing entitlements and have that as one option. And then option two is to add multifamily uses and retail uses to Pod C, or it's now Pod E. And that's 305 multifamily units and 15,000 square feet of retail. Next slide. Overall key staff findings, they found it compatible and consistent with a comprehensive plan. The RMU 35 land use category is a mix, calls for a mix of urban uses. It's consistent with objectives 34 with an urban level of intensity. We are well below the maximums that would be allowed for multifamily, and everyone's recommending approval, and we actually result in a reduction of 1,580 daily trips. And with that, I'm here to answer any questions. Rob Folt from Links and Associates is also here if you have questions. But the reason why the reason why we had to go two options for development is to deal with the new access standards that the county adopted. And so we needed to just change that one area and the access points for that. Otherwise, it was too awkward to try to fit it all in within one option. So that's why we have two.
Just one quick clarification for the record. So there's a waiver request for that 2-to-1 required setback, and that already applies to your existing approval.
Correct.
That's correct. So this is just to add it for that.
Correct. Just to carry that over to this, and staff has found that approvable.
All right. Understood. Thank you. That was my only question. Appreciate it. Development services, please.
Hello, Tim Lampkin, Development Services. I am going to share my screen. All right. And the location is in the Brandon.
Excuse me, we're not seeing your screen.
Oh, no. Okay. Are you seeing anything?
Just you.
Just me. Okay. Hold on. Sorry. Let's see.
If you have your presentation open already and you go to share in the WebEx session.
Are you seeing it now?
No.
Okay, hold on.
So what you need to do is share your screen, not the PowerPoint presentation within WebEx.
Okay. Since that is what I'm doing, but hold on. If everyone could just bear with me 1 second. Thank you so much. Okay, how's that?
No. Okay.
Nope.
So
All right.
you have your PowerPoint presentation already open, correct?
I do, yes.
Okay. So on that share button in WebEx.
I can do it without a PowerPoint.
Mr. Lampkin, why don't we proceed with that? Just do your verbal presentation, please.
Perfect. All right. So this is located in the Brandon community. It's approximately 8.73 acres. The future land use is residential mixed use 35. The surrounding land use is also residential mixed use 35. The immediately surrounding properties are MU 35 on all sides. most of the surrounding area is within the PD. To the north is the PD. To the south is the PD. To the east is the Palm River Road and I-75 right of way. The applicant's proposing two development options. The first option is the current plan, which allows a blending of uses, and option 2 is the 8.73 acre Pod E that's being from the existing 26.96 acre Pod C. And they're proposing to have 305 units of multifamily and 15,000 square feet of retail. And the Planning Commission, Transportation, Environmental Protection, no one had any issues. Staff finds it approvable. And that concludes my oral presentation.
Thank you so much. I appreciate it. Let's hear from the Planning Commission.
Carla Llanos with the Senior Planner with the Planning Commission. Okay, so first of all, I want to make a correction on the dais. The correction is to a typo to the staff report from 350 dwelling units to 305, just a note for the record.
I do have your revised report.
Thank you. The subject site is currently vacant and consists of a total of 8.7 acres in size and is part of a larger approved plan development, which is 02-0139. The subject property is located within the urban service area. It falls within the limits of the Brandon Community Plan, and the property's future land use designation is Regional Mixed Use 35. The Regional Mixed Use 35 future land use category is predominant in this overall in this area. So the applicant is requesting a major modification with two options. So the first is they are looking to modify, obviously, the PD to develop the remaining 8.7 acres of vacant land. And the applicant is choosing to retain the current existing entitlements as option 1, which currently allows for 389,000 square feet of retail or research corporate park uses and 90 hotel rooms. As per the current conditions, the non-residential square footage is allowed to be converted to additional hotel rooms and vice versa at a conversion rate of 190 square feet to 1 hotel room. So option 2 is to develop 305 multifamily residential units and 15,000 square feet of commercial neighborhood uses. On 8.7 acre site, the maximum intensity that can be considered is 757,944 square feet. The proposed square footage is well below the maximum that can be considered for the site and therefore is consistent with the intensity expected in the Regional Mixed Use 35 future land use category. The proposed modification is consistent with Objective 34 of the future land use element, which calls for an urban level intensity and mixed use developments along the Interstate 75 corridor. The intent of the Regional Mixed Use 35 future land use category is to form a regional activity center, which incorporates internal road systems, building, clustering, and mixing of uses. The modification request is consistent with the Regional Mixed Use 35 future land use category as previously mentioned, and the request for that major modification supports the vision of that Brandon Community Plan. Overall, the proposed rezoning will allow for a development that is consistent with the goals, objectives, and policies of future of Hillsborough County Comprehensive Plan for the unincorporated Hillsborough County. And it is compatible with the existing and planned development pattern found within the surrounding area. So based upon those considerations, Planning Commission staff finds the proposed rezoning major modification consistent with the future of Hillsborough Comprehensive Plan for the unincorporated Hillsborough County, subject to conditions proposed by Development Services staff. And I will stand for any questions.
No questions at this time, but thank you. Is there anyone in the room that, or online that wants to speak in support? No one online or in opposition? Seeing no one? All right, Development Services, I just have one question. I just noticed in the proposed draft conditions, it looks like, unless I'm not reading this correctly, and this is for Mr. Grady or Mr. Lampkin, whoever would like to answer, it identifies option 1 and it talks about a reference to the hotel conversion for the non-residential square footage. But then when you go to option 2 and it lays out that new proposed use of the 305 multifamily and the 15,000 of CN uses, it also makes a reference to a conversion of hotel rooms. Is that accurate that there's a hotel option in option 2?
So that is correct, unless the applicant is not proposing to put a hotel. That is so I believe that the applicant wants to have the hotel as an option.
All right, well, we'll ask Ms. Corbett when we get to her and clarify that. All right, Ms. Grady, did you have any comments? And we'll just clarify it with the
We'll just
applicant.
clarify with the applicant.
All right, then Ms. Corbett, if you could help us, we're ready for rebuttal. Are you aware of the condition I'm looking at?
Yes, I am. I'm going to phone a friend. I see Dallas Evans, who is our civil engineer on the video. And I'd ask Dallas, I'm not aware of any reason that we're trying to retain a hotel conversion here. Are you?
In option 2.
In option 2.
No, there wasn't. Actually, the hotel that was anticipated has been built out already. It was just that when those two conditions were split out, it was retained in both conditions. There was no specific need
Yeah,
for that.
we had a little struggle collectively trying to figure out how to create an option 2 that didn't adversely affect anything else. And I don't think that it was anticipated at any time that the hotel conversion was important to.
All right. So it would be acceptable to you to strike that portion that refers to the hotel room under option 2.
Yes, because we've created a new pod is what we've done under option 2. And then for the multifamily and the retail, that was the intent of the modification.
Understood. All right. Thank you for that clarification. Did you have any additional comments before I close? All right. Then we'll close major modification.
Ma'am, I'm sorry. I need the address from Dallas Evans.
Oh. Mr. Evans, if you could give us your name and address for the record, please.
Yes, Dallas Evans, 3810 North Dale Boulevard, Tampa.
Thank you so much.
Thank you.
All right, then if there's nothing else, we'll close major modification 22-0452 and adjourn the hearing. Thank you all for your time and testimony.